everybody. It's 9 o'clock. We'll go ahead and start the 9 o'clock docket, taking open announcements. Just some housekeeping notes first. For those appearing via Zoom, until it is your turn to testify or talk, I'd ask you to keep your microphone muted. Also, if you have not clicked that button that stops your video, we can see what you're doing. And although it may be entertaining at times, it can be a distraction. So please, if you wouldn't do it in the courtroom, don't do it if you have your video going. For those in the courtroom, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. It is your individual decision, and I'm not going to tell you how to make that decision. The only people I do is because of the inmates. For obvious reasons, I do require them to wear masks. And so with that being said, Mr. Baker. Yes, sir. Who is this? I got it. All right, this is cause number CR 20-0366-392, the state of Texas versus Catholic for trial by is there a plea offer on the table? We'd have to take it back to grand jury. All right, and I'm sure you've explained this to your client. I know you have to take this. We're to go to trial, even on this charge. If we're to be found guilty, man, you know you couldn't get deferred after that. I'm sure that's the lawyer. Okay. All right, well then I'll reset it. Do we need to reset these? Well, if this one they're closed. It's been a week. Well, here's what I'll do then. I won't reset it. If y'all come to an agreement with Kevin, you can set a plea date. If not, I will assume it's going to the grand. All right. All right. Thank you. These are cause numbers CR 19-087071 and 72-392. Also CR 20-0256, 0275, and 0333-392. I think I already signed. All right, Mr. James, I granted a continuance because Mr. Hunt just recently came on to your case. It wouldn't be fair to you to put him in trial quickly. So we have to reset date then. see anybody else in line. Do we have anybody on Zoom ready, Mr. Green?
I'm ready, Judge.
Okay. All right, this is cause number CR 18-0167-392. Richard Bullhead. This is set for trial doc status.
Judge, I assume Ms. Palmer notified you the same thing she and I talked about earlier this morning. I can't hear anybody that's at the bench through the Zoom. I can hear you, but I can't hear anybody else. And I can barely hear you. It's not as loud as it normally is.
Change the batteries here, but what I'm going to do is I've already had a bench or a in-chambers conference about this case. So what I'm going to do is I'm just going to reset this. What date? How far out y'all need? June 14th.
What was it, Judge?
June 14th at 9 a.m. Got that, Mr. Allhaver?
Yeah, is that another Zoom meeting or do I need to be there live?
Just, it depends on what y'all get worked out. If y'all don't have anything worked out, then you can do that via Zoom. If you do have something worked out, some kind of resolution, I need to hear it before then.
Hey, Rick,
Unless you hear otherwise.
Rick, I'll reach out to you tomorrow.
All right, June 14th at 9 a.m., right?
Yes.
Sure.
All right, thank you.
Thanks. May we be excused, Judge?
Sure, thank you.
Thanks.
All right, continuing on with open announcements, 9 a.m. docket. All right, well, we'll take a quick break and we'll replace the batteries.
Start on page 13. And Kevin Cantrell.
Kevin Cantrell.
Right here, sir.
All right, these are cause numbers CR 19-0052 and 0053-392, both styled state of Texas versus Kevin Cantrell, set for trial docket status.
State's right. And Your Honor, it'll kind of be the same announcement for most of my clients. I'm trying to get some of these things worked out today, but I was in jury trial up until last night at 7 p.m. and I was preparing for trial last week. I have gotten some new offers this morning that I've relayed to clients. Some of those have rejected it. Some are going to want to think about it. With regards to Mr. Cantrell, they've made him a time served offer of 149 days on a deadly conduct. At this point in time, he's rejected that offer. I've made a counter offer to the state. I'm hopeful we can continue to negotiations, but at this point in time.
Well, let me just do it because this is the
No,
2019 case.
this offer expires right now.
It expires, so the offer
Trial.
expires today.
Trial, yeah.
Do you need time to think about it? Y'all want to talk about it?
I know.
Okay, then it sounds like Mr. Cantrell will go, we might be able to get him a trial real quick. And this is a second degree felony?
Yes,
Yes, sir.
So does he have any priors that you've alleged?
I'd have to
For
look at
enhancement
this form
purposes?
Not in the indictment that I'm aware of.
Okay. All right, so it's 2 to 20 unless there's some, and it's ag, so it's 3G. Okay. So if he were convicted, he could not get probation. No setting, right? Okay, but he can move up real quick after today. Okay, well, Mr. Cantrell, again, I'll note that the offer's been rejected. I guess, is it open till the end of docket?
Yeah, sure.
Okay, so it's open to the end of docket. If not, then they're withdrawing it. And you'll be on the trial docket and we'll let you know. when the
All right,
trial-
thank you.
Thank
Yes,
you.
sir.
All right. Johnny Carey.
Right, it's cause number CR 20-0122-392, the state of Texas versus Johnny Carey, and set for trial docket status.
States right, Your Honor.
Your Honor, there was also a new offer of 12 months today that was relayed to my client. He's rejected that offer.
All right, well, then the court notes that the offer is rejected, and is this a state jail?
It's a state jail, however, we're seeking enhancement 2 to 20.
Okay, so if he's convicted, it's not less than 2, no more than 20.
That's correct.
Okay, and he's rejecting a what?
12 months.
12 months. All right, Mr. Carey, the court notes you've rejected the offer. Does that expire at the end of the
It
docket?
does, Your Honor.
Okay, and so what number is he? 51? So he's still close. All right, Mr. Carey, we'll let you know when your trial is. Free to go.
Next on the docket is David Crabb, Your Honor.
David Crabb.
He may be in the hallway.
Can't give these cases away. Mr. Crabb, come on up. This is cause number CR 20-0508-392, the state of Texas versus David Crabb, set for trial docket status.
The state's ready, Your Honor.
And Your Honor, there, I believe the current offer or the offer that was made is a 12-month offer on a state jail felony,
9 months.
9-month offer on a state jail felony. He's rejecting that offer and has to place it for trial.
Any enhancements?
There are, it's 2 to 20.
So if he's convicted, it's not less than 2, no more than 20, and he's rejecting a 9-month offer.
That's correct.
Okay, all right, well then, Mr. Crabb, then the court's not going to entertain any more plea bargains. You'll get a trial. You're number 67, but that could change. So you'll get a notice, stay in touch with your bondsman and your lawyer on when your trial is.
Sure.
All right,
Keith Gleason, Your Honor.
Mr. Gleason. This is cause number CR 20-0280-392, the state of Texas versus Keith Gleason, and set for trial docket status.
Yes, Your Honor, I reached out to Mr. Stevens regarding a plea offer, and he was in trial. So I just spoke with him this morning. I don't know if he's had time to talk. Well,
And I think when I visit with the state, they still need to visit with their alleged victim in this case.
Well, what's the offer?
the offer is probation, deferred probation, Your Honor.
Deferred?
Yes,
And I think this one we will be able to get resolved, but I think they need to visit with their alleged victim. If we could reset this one time, it may end up getting resolved.
we just need to get her in the office, Your Honor.
Okay. June, or you got something quicker? Next week?
That's fine.
May 5th at 1:30. Yeah, we already have a docket. I'm, okay, yeah, that's quick. It's Wednesday, right? Yep. May 5th, 1:30. Let me just ask y'all this, if the victim's on board with the plea bargain, will it be a plea?
Yes.
Then we'll just set it for a plea, and if something happens, just let Kevin know. So Mr. Gleason, you'll receive a reset notice. We'll see you May 5th at 1:30 for a plea unless something happens. And the attorney will let you know. As soon as you receive that, you're free to go.
Next is actually past that one. Brian Nichols, Your Honor.
Brian Nichols. This cause number CR 20-0292-173, the state of Texas versus Brian Nichols, set for trial docket status.
It is set for trial docket status, Your Honor. There are some, I think, underlying issues. This is a potential defense of others type case. There's some things where like to
It's
sit
only,
down with the
it's only a
state.
year old.
visit.
so-
I understand, Your Honor, but these cases also were set, our last docket call was 5-6 months ago, and unfortunately, the trial's coming up and other items that get set on the docket. And I didn't have opportunities last week to sit down with the state for preparing for trial, and then trial up until last night at 7. So I have several cases I've already said, let's go to trial on. If we could have one more opportunity, it may resolve itself. If the court wants to set up a trial, we can set up a trial.
I'm fine resetting it for that May 5th. The court's already reset a couple.
Is there an
times.
offer?
Judge, that's what Mr. Stevens and I have been discussing is an offer, and we haven't.
Okay.
I think the prior prosecutor was handling the case had made a 2-year deferred probation offer.
That's a pretty good offer. Wednesday at 1:30, May 5th, 1:30. I say pretty good. I don't know the facts and circumstances, but generally speaking, on a state jail felony, that's pretty good. See you Wednesday.
I believe next is Jeffrey Roberts.
Jeffrey Roberts. Let's see the docket sheet as well. This is cause number CR 20-0178-173, the state of Texas versus Jeffrey Roberts, set for trial docket status.
Your Honor, I believe the latest offer was 5 years TDC, and Mr. Roberts has rejected that offer.
All right, the court notes that the offer is rejected. He will be set for trial. What number is he? 50 or so. Okay, it'll come up sooner or later. All right, but before you go, Mr. Roberts, I'm not going to give you a new setting. Stay in touch with your bondsman and your lawyer, but I'm going to order you to take a drug test today. It's been a while since you took one, so you'll go with probation, take the test. When you get done, come back in the courtroom. We'll go over the results together.
Yes, Your Honor.
All
right. April Watts.
April Watts. It's cause number CR 19-0685-392, the state of Texas versus April Watts. Set for trial docket status.
We are, with regards to this case, there was originally a 2-year deferred probation offer, or apologize, 1-year deferred probation offer. That then changed today. There was a new offer of time served on 4 days in jail. My client is rejecting that offer and has to set for trial.
All right, is this a third?
It's a third.
Okay, any enhancements alleged? So if she's convicted, it's not less than 2 years, no more than 10 years in the penitentiary. Okay. All right, well then, Ms. Watts, the court won't entertain any more plea bargains. You'll get a trial. And so number 38, you're pretty close. All right, you'll receive notice.
Thank you.
And I have one left. I'm gonna circle back around, visit with the state on it.
Not resolving it. Mr. Head,
Announce for Mr. Weiner first on page 15. Raul Castro, he's out in the area, should be.
come on up, Mr. Castro. I'm gonna arraign him first.
Yes, sir.
Use your cause number CR 20-0260-173, set for trial docket status. And then cause number CR 21-0357-173, set for arraignment. Let's arraign him on that new case.
Your Honor, on 0357, Mr. Castro's name appears correctly. He understands the nature of the charge, would waive the formal reading of the indictment, and plea of not guilty for purposes of arraignment.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Are we, Danny, is there an offer to wrap all this up now, or we want these to run together?
We'd like to run them together, Your Honor.
Okay. All right, and so your next two court dates, well, what I'm gonna do is I'm gonna carry trial docket status. Your next two court dates are June 9th at 9 a.m. for discovery status. And July 7th at 9 o'clock for pretrial. And so we will see you back on those dates, and I'm just gonna carry this old case with this new one. However, based upon the nature of the new case, I'm ordering you to take a drug test today. You're gonna go take the test. When you get done, come back in the courtroom. We'll go over the results together.
Come back after.
So take the test, don't leave, come back in here, and we'll talk about the results.
And then, Your Honor, on page 16, Mr. Chambers, he should be bench warranted here. He is present. We have some paperwork to go over and
Okay.
hopefully have an agreed
Mr. Chambers?
disposition.
Gotcha. Now, you don't have to come up. I'm just making sure you're here.
In my case, it's begin on page 1, Your Honor,
Okay.
with
Mr.
John
Cox.
Cox.
John Cox. It's cause number CR 18-0602-392, the state of Texas versus John Cox, set for trial docket status.
Your Honor, I have a couple of items that I'm working on. I think they'll be resolved if the court wishes to set the case for trial. There's apparently a counselor out there. The clinic has been closed. I've been trying to track that person down for months. But if the court would like to set it for trial, the state's okay with that. I just wanted everyone to be aware of what was going on.
Is this not going to be resolved by plea bargain?
Your Honor, I don't anticipate it will be unless there's. some
What's the offer
significant-
now? Is there one?
There's not a current offer, Your Honor.
Are you planning on making one?
I emailed Mr. Head earlier in the week asking, I would like to discuss potential offer.
It's only 3 years old.
I understand.
It's been on the trial docket status now for
Forever, but he's number 16. so
number 16.
we'll
Judge-
we'll either get to him in June or July.
You signed a protective order to release unredacted CPS records to Mr. Head this week.
Okay,
So we need to produce those to him as well.
okay. All right, well then, let's set him on an announcement.
In June or July,
June.
June 14th.
It's an old case. We got to get it tried. So he's number 16,
June 14th is 9 o'clock.
June 14th, 9 a.m. And if y'all get it resolved sooner, just let Kevin know.
And that's for announcement, Your Honor.
Trial
correct?
announcement, yes.
Okay. I'll get with Ms. Pace and we'll look at those CPS records and we'll visit again.
Okay, all right.
Thank you, Your Honor. Thank
Mr.
you.
Cox, we'll see you in June.
Yes. Yes, Your Honor.
Culliver. Culliver.
Culliford, yes, sir, Your Honor.
Daniel Culliver. I can't hear you. Oh, okay. All right, these are cause number CR 19-0255 and 0256-392, both styled the state of Texas. I'm sorry, first styled state of Texas versus Daniel Culliver, and the 256 state of Texas versus Keaton Culliver, set for trial docket status.
We're ready, Your Honor.
What number are they?
24.
We trying them together?
25. I don't think they've been consolidated.
I don't believe there's been a motion to consolidate, Your Honor.
Does Mr. Culver have retired history?
But they're both in the top 25. They're an offer.
Oh, he did have a privilege. I don't know if they can be joined. Yeah, he did have a felony probation. They can't be joined. Your Honor.
One's got a felony conviction. Okay, but they're both in the top 25. They're close.
Okay, we're ready for.
Is there an offer?
There is on Mr. Daniel Fulfer, it was a 10 for 10 probation. And on Mr. Keaton, it was a 10 deferred probation.
Okay. All right, well, gentlemen, you'll get a trial. And so I'm not going to give you a setting yet, but stay in touch with your bondsman and your lawyer, and we'll get a setting out to you when your case comes up. All right, thank y'all. Mr. Humble,
Yes, sir, Your Honor.
Douglas Humble. All right, this is cause number CR 19-0675-392, the state of Texas versus Douglas Humble, set for trial docket status.
State's ready.
Your Honor, we're ready with the one exception. I'm not sure we've got a transcript of the hearing on the motion to suppress yet. I wouldn't think that would take long to put together if it hasn't been done already. And I'll request it. I think we were waiting to see if we were going to be able to reach an agreement, but we will need a copy of that transcript prior to trial.
Is there an offer?
There is 4 years.
Okay, and that's rejected.
Yes, sir, Your Honor.
37.
Number 37. All right, Mr. Humble, you're number 37 in line for trial, but again, stuff please out or goes ahead of you. You could rise up there real quick. I'm not going to give you a reset notice. Stay in touch with your bondsman and your attorney, and when your case comes up, we'll give you notice. Thank you, sir.
And then, Your Honor, if we could skip Ms. Lawler, we may have an agreement on that. I need to just visit with her, but I do have Mr. Whittle here.
You're gonna get sprinkled too.
If we could skip Sprinkle for right now.
Robert Whittle.
I haven't seen him on Zoom this morning. I'm gonna have to contact him.
All right, these are cause numbers CR 20-0462, 463, 464, and 465, all styled the state of Texas versus Robert Whittle, all set for trial docket status.
State's ready, Your Honor.
We're ready, Your Honor.
What number is it? Okay, so down there. Has there been an offer?
It's 40 years, Your Honor.
4-0?
40.
Okay,
Which I'm open to negotiation, but as it stands right now, it's 40 years.
So we got some first degree felonies here.
Yes, sir.
Is there any enhancements?
No, sir, he
No.
doesn't have any prior convictions.
All right, well then, is that offer rejected?
Yes, sir.
And, all right, well, sir, I'm not going to give you a reset notice, but stay in touch with your attorney and your bondsman. When your case comes up for trial, you'll receive notice.
Yes, sir, Judge. Thank you.
Your Honor, I think just for the record, I think the offer was 30. Was it? I believe it was 30. It had
It's a
been
30-year
20,
offer
it went to
rejected.
30, but it's
Either way.
same result. Yes, sir. Your Honor, if I could be excused for a few minutes, get some paperwork together.
Mr. Schmidt, okay. Alrighty, this is cause number CR 20-0281-392, the state of Texas versus Ronnie Wayne Harris Jr. And this was set today for trial docket status. However, a plea has been presented to the court. Is the state ready?
State is ready, Your Honor.
And on behalf of Mr. Harris,
Yes, Your Honor.
all right, sir, is your name Ronnie Wayne Harris?
Yes, sir.
And are you the same person? And you can pull that mask down if you want.
Okay.
It makes it easier to hear you. And you don't even have to wear it for all I care. It's up to you. Sir, are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of assault family violence?
Yes, sir.
If I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
Now you can
Just
lower your
before we
hand.
get started, just let you know, he was also indicted with one enhanced paragraph.
I'm sorry.
He was indicted with one enhanced paragraph.
Okay. The original charge without enhancements is the
Yes,
third
sir.
degree. Is that correct?
Yes, sir.
And we're abandoning that, Your Honor.
And Mr. Harris, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Harris, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Schmidt, do you believe your client is competent?
I do, Your Honor.
The court's going to find he is competent. Mr. Harris, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
But you understand the charge?
Yes, sir.
Well, as indicted with an enhancement, that charge is actually a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years nor more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. You understand that range of punishment?
Yes, sir.
However, it's my understanding that the state, in exchange for your guilty plea, is willing to reduce this to the lesser included offense of a state jail felony, which carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand that range of punishment? And further, they're recommending that the court, in exchange for your guilty plea, convict and punish this as a Class A misdemeanor. A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine up to $4,000. Do you understand that range of punishment? And the plea bargain?
Yes, Your Honor. In exchange for a plea of guilty, the agreed plea recommendation is to reduce that to attempted assault, family violence, impeding breath, but to punish that as a 1244B, to abandon the enhancement paragraph 1, sentence him to 168 days in the Henderson County Jail, but give him credit for that 168 days, attorney's fees and court costs of $290.
I'm retained, Judge.
Understand. Is that your understanding of the plea bargain, Mr. Harris?
Yes, sir.
Is that your understanding, Mr. Schmidt?
Yes, Your Honor.
Mr. Harris, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents here. First is the agreed plea recommendation. Did you read and go over that with Mr. Schmidt?
Yes, sir.
Both the front and the back?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it? The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that with Mr. Schmidt? Did you sign that second page? Do you have any questions about it? Do you have any questions about any of the documents you read and went over with him? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, Your Honor.
You want this plea bargain?
Yes, Your Honor.
Then I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, punished and convicted under 1244B of our penal code? Are you guilty or not guilty?
Guilty, Your Honor.
And are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
Hear the evidence.
Your Honor, state offer states Exhibit 1, the offense report,
No objection.
states Exhibit 2, the inventory discovery report.
No objection.
Admitted.
State rests and closes.
That's close, Your Honor.
All right, Mr. Harrison, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that attempted assault family violence as alleged in the indictment. The court has granted the state's motion to abandon the enhancement paragraph. The court follows the plea bargain, sentences you and punishes you under 1244B of the penal code to a Class A misdemeanor, and sentence you to 168 days in Henderson County Jail with credit for 168 days and orders you to pay your court costs.
Yes, sir.
And sir, before you go, have you had an opportunity to review the judgment in your case?
Yes, Your Honor.
Was your name, the charge, and the time credit correct?
Yes, Your Honor.
All right, sir, good luck to you. You need to see Mr. Halbert to your right before you leave.
Thank you, Judge.
Yes, sir, thank you.
Judge, that's all I have, man.
Sir. He's back 1,000 a day. We have one case resolved. Mr. Stevens.
Page 13, Your Honor.
Keep
Juan
it count.
Yanez,
Who do you have?
Juan Yanez on page 13,
Giannis, come on up.
and we have a plea of agreement, Judge.
Okay. All right. This is cause number CR 21-0124-173, State of Texas versus Juan Yanez, and this is set today for trial docket status. However, a plea has been presented to the court. Is the state ready?
We're ready, Your Honor.
And on behalf of Mr. Yanez,
Ready.
sir, is your name Juan Jose Yanez?
Yes, sir.
And are you, can you pull that mask down? All right, are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance? If I can get you to raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
And you can lower your hand. Mr. Yanez, can you read and write the English language?
Yes, I can.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Yanez, have you ever been treated into any mental health or emotional issues? Do you understand what's going on in here today? Mr. Stevens, do you believe your client is competent?
Yes, Your Honor.
And the court's going to find he is competent. Mr. Yanez, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom? If you understand the charge. Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days and a fine, or up to 2 years, and a fine not to exceed $10,000. Do you understand the range of punishment in the plea bargain?
Your Honor, it's 15 months confinement in a state jail felony facility with credit for 334 days served, $650 in attorney's fees, court costs, lab restitution, and we're asking the court to take into consideration CR 20-352-173.
Is that your understanding, Mr. Yanez? Is that your understanding of the plea bargain, Mr. Stevens?
Yes, it is, Judge.
Mr. Yanez, a few minutes ago, you told me you could read and write the English language. Correct? I'm going to show you two documents here. First is the agreed plea recommendation. Did you read and sign both the front and the back of Mr. Stevens? Do you have any questions about it? The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document? And did you sign that second page there? Do you have any questions about it? Do you have any questions about any of the documents you read and went over with Mr. Stevens? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
You want to waive your right to a jury trial and enter into this plea bargain? And I'll ask you, sir, how do you plead to the state jail felony offense of possession of a controlled substance?
Yes, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, I have states 1 an offense report, states 2 is Michael Morton compliance, and states 3 is a lab report.
No objections.
All admitted?
State rests.
Fence rest.
All right, Mr. Yanes, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the indictment. Court will follow the plea bargain, sentences you to 15 months in a state jail felony facility with credit for 334 days. The court in punishing you has considered that CR 20-0352-173. The court orders you to pay your attorney's fees, court costs, and lab fees. Before you go, a couple more things to go over with you, Mr. Yanes. Did you have an opportunity to review the judgment? All right, was your name, the charge, and the time credit correct?
Yes, sir.
All right, and finally, sir, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. You're now remanded back to custody of the sheriff for transport to state jail. First, you need to see Mr. Halbert. Good luck to you.
Thank you.
Yes, sir.
Thank you, Judge. Might be excused
Yes, sir.
this afternoon.
What's today? 30th, 29th, 29th. Back in front of me. Yes, ma'am, Miss Altier.
At the top of your docket this morning, Zachary Crawford.
Zachary Crawford. All right, this is cause number CR 19-0517-392, the state of Texas versus Zachary Crawford, set for trial docket status.
Yes, Your Honor, and we would ask for a continuance. Mr. Crawford advises me he has a cell phone that's locked that has exculpatory evidence, and we're going to file a motion for an extra.
2-year-old case.
I understand, Your Honor.
He's just now telling you he's got a cell phone that's
He
locked.
he has been trying to unlock it himself, but he's not been able to do that.
So how do you plan on unlocking it?
Well, he's just a layman. There are
I mean, the
programs.
FBI can't even unlock an iPhone, yet mine seems to unlock and call a random person when it's in my pocket. So I don't know how that happens. But I mean, it's a 2-year-old case, and now the defendant's come 2 years later and saying, hey, I've got this exculpatory evidence.
Yes, Your Honor.
What's the state feel about that?
She did reach out to see if our expert or somebody would open it, and I said, we're not touching the phone. She can apply for an expert or whatever, but
Well, that's not happened. I mean,
it hasn't happened, so.
you court appointed?
I am, Your Honor.
All right, well, then the continuance is denied. Is the state ready?
State's ready.
Well, I guess we can be ready if we can. When is the date of the trial?
What number is he? 33, it's going to be around July or August. So, Mr. Crawford, you got exculpatory evidence on that phone, and it's your evidence. It behoove you to have said something about this a long time ago. That's why we have arraignment and discovery status and pretrial status. And how many trial docket statuses now? About 5 or 6. And now we're just finding out about this. So anyway, sir, you'll receive a notice on when that trial is, probably be around June or July. So when you get a continuance, just because of where he's at. I mean, you're not an official continuance, but you're getting time.
Sure.
And I'll note, today is April 29th. This was indicted as a 2019 case. We've had numerous court hearings, and you've got about another 2 months before his case ends up probably in the top 10. So you've got time.
Would the court entertain a motion for an expert?
You got to file, you're just going to have to file
I
it.
will. Your Honor.
I've not received any motions.
Okay.
And Your Honor, there's a 2-year TDC offer. I'm going to extend that for till June 1st.
Okay, all right. I thank you. We'll see you, Mr. Crawford. You won't have a reset notice now, but stay in touch with your bondsman and your attorney and we'll give you a notice. Thank you, sir.
I have nothing further this morning. May I be excused also?
Yes, ma'am.
Thank you.
Motion for continuance also has to be filed and sworn to. Yes, sir, Mr. Mills.
Page 7, Robert Bradley.
Mr. Bradley, come on up. I saw him here earlier. It's cause number CR 19-0288-392, the state of Texas versus Robert Bradley, set for trial docket status.
Judge, we've reached an agreement on the case. They're going to, I guess, dismiss this case and file an information to a attempted tampering with physical evidence for 1244A plea to time served. So if we could set that off for whenever we can do it.
How long did it take y'all to file an
It won't take
information?
us too long. We just have the 10-day. I think they'll waive the 10 days.
And I'll waive the 10 days, Judge. I can tell the court he has an issue he's got to take care of in Van Zandt County today, this afternoon. That's kind of related to this. And so he needs, I've got to be here this afternoon, but he really needs to go take care of his business over there so we can do this. So maybe
I understand.
next week,
How about Wednesday,
next Wednesday,
May
Is that
5th,
the 5th.
Cinco de Mayo?
That is Cinco de Mayo, isn't it?
It is Cinco de Mayo. I know that because my son
that's
was
good.
born 5405 and I kept thinking if you'd have waited one more day, it would have been 5505.
That's true.
State's good with that.
Okay.
That's good. Next Wednesday's good.
All right.
Thank you, Judge.
All right, Mr.
9
Bradley,
o'clock.
take care of your business in the free state of Van Zandt and we'll see you back here Wednesday,
9 o'clock.
9 o'clock.
All right, thanks.
You'll get a reset notice. Don't go anywhere yet.
I can't hear him. Is he talking about me? Kerry McCoy.
Kerry McCoy. That's cause number CR 18-0207-392, the state of Texas versus Kerry McCoy, set for trial docket status.
Your
Judge-
Honor,
Oh, I'm sorry. Go ahead.
sorry, the state has made a 5-year deferred offer. I'm not sure if that's going to be accepted, but the state is ready for trial.
And it's not going to be accepted.
I see the indictment. This is the one with Mr. Gamble.
Yes, sir.
Did Mr. Gamble take care of his business?
He did, he pled.
He pled to, I think, 5 years deferred.
Can I see the docket sheet? Lord. All right, here's what I'm gonna do then. What number is she? 14. There's a chance she could go this next time around then.
When is the trial?
Well, we have 2 trial settings for June.
Next, pretty much next month. And this is a first degree felony.
21st and the 28th will be trial weeks,
That's the last week of June.
the last 2 weeks of June.
So the 21st, I'm okay. The 28th, I'm gonna be out of town.
Okay. We have just a more special set for the 20.
That probably may work itself out. It's a first degree felony,
Yes, Your Honor.
5 to 99 or life, and there's a 5-year deferred offer that the co-defendant took. I'm just putting that on the
That-
record so everybody
That's correct,
understands.
Judge.
Okay. All right, well then, Ms. McCoy, I'm gonna set you for trial announcement on
June 14th, 9 o'clock.
June 14th at 9 a.m. And I know Mr. Mills has explained it to you, and I don't know anything about your case other than what you're indicted for. I hope you know that. Nothing. However, if you are convicted by a jury, then your punishment range You can't get it deferred. You understand that? It would be not less than 5 years, no more than 99 years or life in prison. You understand that? Okay, and if you are convicted beyond a reasonable doubt, it's too late then to say, I'll take the deal because it can't happen. I mean, it can't. You understand that? So, but before you go today, I'm going to order you to take a drug test. So you'll go take the test, and when you get done, come back in the courtroom and we'll go over the results together.
Perry Peters?
Perry Peters. Give these cases away today. All right, this is cause number CR 20-0329-173, the state of Texas versus Perry Peters, and that is set for trial docket status.
Your Honor, I have sent subpoenas for CPS records, counseling records, and pediatrician records. There's not an offer at this time. I have the defendant scheduled to come in on Monday. I've not been able to meet them so far. The state would ask for another setting.
That's fine with us.
What number is he?
62.
Okay, I don't mind. What, June? No, I mean, well,
He's 62, so he's on the.
yeah, but they still have discovery outstanding, so I'd like to set it to make sure that's resolved.
I just sent subpoenas within the last week, so it may take 60 days.
Because I'd kind of like to know where we're at. And since there's still discovery out there, I ought to set it for, we'll just call it a status. Because I hate to set it for trial docket status. You got it, and then
Right.
ask you
Something
whether you're
comes
ready
up.
or not.
Right.
June 9th at 1:30.
June 9th at 1:30 for status. So I'm gonna back this case up to status since we're waiting on discovery. Got that, Mr. Peters? June 9th,
Yes, sir.
1:30 for status.
1:30?
Did I say, did you say 1:30?
June the 9th.
He said 1:30. 1:30.
1:30.
Okay, thank you.
Yes,
May I give you
sir.
excuse, John?
Yes, sir.
Next.
Sloan.
Lost my sheets now. Whoever's next on their. judge.
Sloan.
Yes, sir.
Roderick Sloan.
I hadn't heard from him in a good while.
What is the bondoffice.com?
They've been around for a while.
Well, their client hasn't. When's the last, have we already filed them? Or- Can I see the docket sheet?
I was thinking he didn't show up before.
Yeah, that's what I'm thinking. That name sounds familiar.
December 17th.
No, he was here. Yeah, on December 17th, there was an offer of 5 years rejected, placed on the trial docket. So
And they've now offered him probation, so I wish he'd have been here.
well, all right, let's do it officially. The state of Texas versus Roderick Sloan, cause number CR 19-0391-392. Is there a Roderick Sloan in the courtroom? I see no one. I hear no answer. Is there a Roderick Sloan appearing via Zoom? I see no one. I hear no answer. His name was called 3 times in the lobby. He did not answer. The time is now 9:54. The docket was set today for 9 a.m. Mr. Sloan received notice. Court will entertain a motion.
Judge, state's ready and present. This time we'd seek the bond forfeiture in this case.
Granted, Capious will issue, he'll be held with no bond. And if he said, if you get a hold of him or somebody can get a hold of him,
Okay.
I'll be here all day.
Jordan Wright.
Jordan Wright. Can they not hear me out there?
I don't think so.
I just didn't know if when I say it, they could hear it. All right, this is cause number CR 19-0338-392, the state of Texas versus Jordan Wright, and set for trial docket status.
State's ready on.
Judge, we're ready. They did make Mr. Wright a new offer last week for, to reduce the case to a misdemeanor, let him plead for 1 year, probated for 1 year, and he's rejecting that offer.
You need time to talk?
Yeah, we just really have a decision on it. Give me some time to think.
Yeah, Judge, maybe if we could reset him till this afternoon perhaps, or how long you need to decide?
We'll just set it up to next time.
Just
Well,
whenever the court wants to reset it, if we give him one more status. They just made the offer. I just did tell him about the probated misdemeanor 1 year probation offer this
Would
morning.
it be
so-
contingent on him passing a drug test or not? Because I may order him to take a drug test today.
Sure,
Just based on appearance and demeanor.
sure. I may extend that offer.
To this afternoon?
How long does it need? 2 months?
Well, like, I'm not trying to talk, I just really ain't much to say it on, you know, I don't.
Yep.
Not trying to think.
Okay, Judge, this is the first time I've related. He's always declined offers in the past, every time we've come, and then they did make him a first time misdemeanor offer for
Understood.
probation and kind of thrown that at him this morning.
So it
And
was this morning. When, how about
May 5th at 1.
May
That'll
5th,
be-
1:30?
that'll be fine. Just
Thank
that's
you, Judge.
next Wednesday at 1:30.
Yep.
Got that? Next Wednesday, 1:30. Okay, call me.
All right, see you May 5th, 1:30, Mr. Wright.
Thank you.
I'm sorry, you just got it this morning.
Well, he just found out about it.
I got,
I found out about it last week, but he just found out about it this
I
morning.
will tell you, I was almost ready to drug test because of his appearance and demeanor though.
I think that's all I have for this afternoon.
Yes, sir.
Thank you.
All right, see you. Mr. Stevens. Yep. Dennis Neal. This is cause number CR 19-0656-392, the state of Texas versus Dennis Neal. Set for trial docket status.
Your Honor, we have reached an agreement. We have prepared a jury waiver. There's some paperwork that needs to get filed in reference to this case, and I think we'd ask to set it maybe on that May 5th date for a plea.
Okay, all right,
Your Honor, if I may put the agreement on the record.
sure.
It would be second degree injury to a child, 10 years probated for 5 years with sex offender conditions, not to include sex offender registration. Protective order for the victim's lifetime.
And is the complaining witness on board?
We have not talked to the witness, the victim about this. We will reach out to them just to double check. We just made the agreement about 10 minutes ago.
Okay, all right, well, then I need to take certain testimony from him for the waiver of jury. Mr. Neal, I'm going to put you under oath, but I'm not going to let anybody ask you any questions about the alleged offense. I'm just going to ask you about this document. You understand that? All right, so if you'll raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Neal, the court has been presented this waiver of jury, and I'm just going to ask you, sir, is that your signature on there?
Yes, sir.
All right. Do you understand that both the United States Constitution and the state of Texas Constitution guarantees you a right to trial by jury? You understand that?
Yeah.
Nobody can take that away from you. Not your lawyer, not the state, not me, not anyone, not even the governor. It's your right. You understand that? And have you gone over all of this with Mr. Stevens?
Yes.
And is this what you want to do?
Yes.
All right. And Mr. Stevens, do you believe that your client has executed this waiver of jury knowingly, intelligently, and voluntarily?
Yes, sir.
Mr. Stevens or Mr. Neal, do you have any questions about this?
No, sir.
Do you understand that if you go, if somehow this deal breaks up, so maybe the victim, the alleged victim says, I don't believe in that, and the state pulls the offer, is this contingent on this stuff?
Your Honor, as far as I don't anticipate there'll be any issues with the alleged victim. She's been in communications with my client's wife. She's fixing to be 18. I don't anticipate there's gonna be any issues, but obviously if the court was either to reject the offer or something of that nature, I mean, this waiver of jury is so that we can get to next week and take it off your trial docket, because these cases are getting pretty old.
I understand, but once he waives the jury, then, there's some hoops you got to jump through to get it back.
Well, what I would then probably ask is if the court could take it under consideration and set it for a plea on the 5th. And then if for some reason it breaks down, I don't anticipate it's going to break down, but
Here's the deal. If it's contingent on this, if his execution of this is contingent on the offer, well, then I'll abandon it.
okay,
All right.
I'm
So,
good with that, Your Honor.
all right. Well, then the court finds that the defendant has signed it knowingly, intelligently, and voluntarily. Counsel for the defendant has signed it and the state has consented. Therefore, I'm consenting this the 29th day of April. And if this is truly contingent on a plea bargain and it all blows up, well, then I'll restore, or I'll basically abate it or abandon it, whatever language you want to use.
Thank you, Judge.
All right.
Maybe-
When are we doing this?
maybe-
May 5th, 1:30. We'll see you May 5th at 1:30.
Thank you.
Yes, sir. Count that as one. I'll put these in. I'm making my little tick marks, but that one's parenthetical. Maybe like Barry Bond's record, maybe an asterisk. Okay. Yes, sir. Thought you were gone.
Well, I was. So I think Carrie McCoy may be going, she may be about to fail the drug test for marijuana. And so I think that she's going to take the plea offer of the deferred. If we could do that this afternoon at
Sure.
1:30, would that be okay?
Absolutely.
Okay. She's still over there, hadn't tested yet, but she's over there, so she'll be tested. Good, okay?
Can we get a reset notice in her hand for 1:30? Carrie McCoy?
Yeah, yes, sir.
Can we go get her?
No, we'll just give it to you. You can just hand it
Okay.
to her. Mr. Head,
I believe we're almost ready on Mr. Chambers for a plea. And we'll
Okay.
have a plea on Ms. Lawler. We stand some paperwork.
Gotcha. all right, that's fine. I probably need to take a small break anyway. All right, so the court's going to take, let's take about a 15-minute recess and we'll reconvene. All right, continuing on with open announcements on the morning docket, Mr. Head.
Your Honor, Justin Sprinkle is on Zoom. He had thought the hearing was at 1:30 and we contacted him and he's there.
One that's in Arizona that you allow to zoom in.
And it's
Mr. Sprinkle, can you hear me?
Yes, I can hear you, Your Honor.
All right, I'm going to call your case then. This is cause number CR 18-0709-392, the state of Texas versus Justin Sprinkle, set for trial docket status.
State's ready, Your Honor, and we filed a request for a special setting.
Okay,
That is my understanding, Your Honor. We're ready. It's my understanding they've requested a special setting.
and I mean, I know the state understands special setting just means we special setting number one, but if for some reason it pleads out, we can still have the next full
I
case.
under- And if we need to set this on that if it's too far out or the court wants to set it earlier, then
We're just about special set on number ones for the whole year, for the rest of the year. So, special set on number two.
that would be fine.
Okay, as a number two. One that you think may have a chance of resolving with Mr. Head's not on and Ms. Pace is not on. While he's doing that, Mr. Roberts, pass your test, you're free to go, sir. Yes, sir.
How long do we think we need?
They said they were ready.
How long?
Oh, how long for the trial?
I anticipate about 5 days.
Okay, a whole week.
Have a trial, say open on August 16th. We gotta finish in 5 days, but we got murder starting next Wednesday.
August 16th, he's number one.
Number one.
Number one, August 16th. Is that jury selection August 16th?
Yes.
Because I'm going to consider this announcement.
Well, I've got an announcement.
Oh, do you? So August 16th, 8:30 a.m. for jury selection.
And then August 9th, 8 9 o'clock. So jury trial.
August 9th. I'm already taking the announcements ready, but we'll just set that for an official announcement today. Okay, so for the cases behind it.
Then we can handle any pre-trial motions, evidence,
Right.
you know, all this.
Okay.
And I apologize. Can you give me those times one more time?
August 9th, 9 o'clock for jury trial announcement. And then August 16th, jury selection. 8:30.
Thank you.
You got those dates, Mr. Sprinkle?
I do, Your Honor.
Okay, then we will see you August the 9th at 9 a.m. and I need to see you in person. And as well as on August the 16th for jury selection.
Yes, Your Honor.
All right, see you in August. You can log off. Thank you, sir.
And Your Honor, we should have an agreement. I think we're ready on Mr. Chambers, Mr. Weiner's case on page number 16.
You got it? It's okay. Thank you, man. Let me look at it real quick. Okay. All right, this is cause number CR 19-0497-392, the state of Texas versus Jason Allen Chambers, set for trial docket status today. However, a plea has been presented to the court. Is the state ready?
Yes, sir.
And on behalf of Mr. Chambers,
We're ready, Your Honor.
right, sir, is your name Jason Allen Chambers?
Yes, sir.
And are you the same person that was originally indicted for this felony offense by a Henderson County grand jury for possession of a controlled substance?
Yes, sir.
Can you pull that mask down just a little bit? And if I can get you to raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Chambers, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen, you enter into this plea bargain, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Chambers, have you ever been treated for any mental health or emotional issues?
Yes, sir.
Do you understand what's going on in here today?
Yes, sir.
And I'll just stop right now. And, you know, Mr. Head is Mr. Weiner's law partner, and you're okay with going forward with this today. All right. And Mr. Head, do you believe Mr. Chambers is competent?
I do, Your Honor.
All right, then the court's going to find that he is competent. Mr. Chambers, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud against you here in the courtroom?
Yes, sir.
But do you understand the charge?
Yes, sir.
Is this a third?
Your Honor,
No, this is a, go ahead.
this is state jail. There has been an abandonment of the enhancement paragraphs.
So it's 17 months. I see it.
Yes.
All right, well, the original charge without any enhancement paragraphs is a state jail felony, and the state has agreed to abandon those in exchange for your plea. The punishment range for a state jail felony is not less than 180 days, nor more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand that range of punishment? And the plea bargain?
Your Honor, the plea bargain calls for 17 months in state jail, $1,000 fine, and it will be running concurrently with a conviction that was held in February in Brazos County. He's presently in the institutional division. And so the agreement would be that it would be served concurrently with that, and he has credit for 407 days.
And then attorney's fees and court costs?
Yes, sir.
That's your understanding of the plea bargain, Mr. Chambers?
Yes, sir.
Is that your understanding, Mr. Head?
It is, Your Honor.
Mr. Chambers, a few minutes ago, you told me you could read and write the English language. I'm going to show you a couple documents here. First is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Head?
Yes, sir.
Did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those pages, Mr. Head?
Yes, sir.
Did you sign the second page there?
Yes, sir.
Any questions?
Yes, sir.
Any questions about any of the documents you've
No,
signed?
sir. I agree with that. I agree with everything.
I didn't ask if you agreed. I said, do you have any questions?
Yes, sir.
All right. All right. Well, if you read and went over these with Mr. Head, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
You want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that state jail felony offense as alleged in the indictment? Guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I hear the evidence.
Your Honor, state offers states exhibits 1, 2, and 3 that have been previously provided to counsel. Offense report, lab report, and submission of lab.
No objection.
Admitted. Anything else from state?
No, Your Honor.
Rest and close?
Yes.
No objection, or no additional evidence. Rest in motion.
All right, then, Mr. Chambers, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense. The court's abandoning the enhancement granted the abandonment of the enhancement paragraphs, follows the plea bargain, sentences you to 17 months in a state jail felony facility with credit for 407 days, orders you to pay your fine, attorney's fees, and court costs. And this case will run concurrent with the sentence you are currently serving. And sir, before you go, have you had an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir, now that you've been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm. If you have any questions, consult an attorney. You're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, sir. You need to see Mr. Halbert over here before you leave. Good to see you.
Don't see you.
Don't see you anymore in here. We don't do
I know
juveniles.
it, and I regret it. Matter of fact, Mike invited me back this afternoon.
The only thing I have left is Miss Lawler. We are working on some paperwork on
Okay.
that. Would the court prefer for us to try to squeeze that in this morning? or I can do it
Whatever
back
you wanna
this
do.
afternoon?
If you need to get out of here, go to the office. I can come back this afternoon. Or
Judge,
I'll be
if-
here.
If you have time, I think it may just take a little while to go over the paperwork and everything, so I'll go do all that and we'll just do the plea at 1:30 if that's okay.
That'll work.
Thank you, Judge.
Miss Moore. Lawler. We'll bring her back at 1:30.
Then, Your Honor, I do have Mr. Castro and it appears.
Oh,
we just
yes.
Got that.
Can I see the docket sheet on Castro? I don't think I've got this in before. Oh, I know why, because of the new case. That's why. All right, Mr. Castro, this is cause number CR 21. That, I don't know. I was trying to figure out why I drug tested again. It's because of the new case. I don't need those. All right, CR 21-0357-173, the state of Texas versus Raul Castro. Mr. Castro was arraigned on a new case as well as held docket status on a previous case. And based upon the nature of the new case, the court sent you for a drug test. And it appears as though you have tested positive for methamphetamine and amphetamine. And so, sir, you get one free chance with me. I'm going to place conditions of bond on you. You are not to consume alcohol, illegal drugs, or controlled substances that are not prescribed. And illegal includes marijuana. And so the next time you come in June, I'm going to drug test you again. And if you test positive, you may not go back out that door. You may go out this one. You understand? If you need help, ask. There's lots of help out there.
Yeah.
Google it.
It was.
That's all. Don't. That's all right. You don't need to tell me anything else, but just know that. So here's your conditions of bond. As soon as you receive your copy, you're free to go, and we will see you in June.
Okay. Yes, signature, address. And phone number, yeah. Just saying that you're getting a copy of this. Address and phone number.
Bless you. June 9th, yes, sir.
This one's always complicated.
I believe that's right. Did we get a reset notice already?
Yes.
Okay. Okay, all right. Your Honor, I'll be back at 1:30 if
Yes,
that's
sir.
okay.
See you.
Thank you. Your Honor.
Ms. Moore.
There are several, starting on page 9. At the top of that, Langell Jackson.
Yes. Langell Jackson. This is cause number CR 20-0294-173, the state of Texas versus Langell Jackson, and set for trial docket status.
Your Honor, this is Ms. Jackson. The prosecutor and I have been negotiating and we received a new offer, kind of a revised offer today. And I think Ms. Jackson is inclined to likely accept that, but he gave her a little bit more time to do that. If we could have maybe a reset date for a few weeks.
Well, I can, but have you seen that?
Well, I just now was handed this when she came out. There's a one for you, but-
She's got a capious profile. Have y'all ever worked out a
She'll
deal?
be able to get this resolved, she said.
Yeah. But I've got to place her in
Right.
custody.
He has to take, yeah, but, So she's gonna be in and out. I think she'll be able to take care of this. If we could, hopefully it doesn't affect the plea bargain offer. So there's a new offer for 90 days to punish this as a class A misdemeanor. And I told Ms. Jackson that this morning, and she, if the court would give her a little bit of time, she's working and trying to figure out if she can make that work.
I'm gonna just have any time credit.
I don't think much, Judge.
Okay. All right. Do y'all want to, well, I'm going to reset it then. How long?
Do you have a date next month, Your Honor?
Sure do. June 9th.
Ms. Moore will be here June 9th at 1:30.
June 9th, 1:30. All right, we'll see you June 9th at 1:30, but unfortunately, Ms. Jackson, I would hope that other courts would abide by my warrant, so gotta have you have a seat over here in the jury box.
My other cases are pleas. Do you just want to go down my other cases that I have are all plea bargains?
Yeah, we just go down the line.
Okay, Mr. Oliver's the first one.
Dylan Oliver. Keeping my tally. Good night. Do you count this as two since there's two cases? How are you counting? That's what I'm gonna do. See, so he's gonna plead on one case. Consider the other. Okay. All right, this is cause number CR 20-0239-392. The state of Texas versus Dylan Don Oliver set for trial docket status. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Oliver,
And Mr. Oliver's present, ready?
all right, sir, is your name Dylan Don Oliver?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of possession of a controlled substance?
Yes, sir.
I need you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And Mr. Oliver, you can lower your hand. Can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
Mr. Oliver, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here today?
Yes, sir.
And Ms. Moore, do you believe your client is competent?
I do, Your Honor.
The court finds that he is competent. Mr. Oliver, I know that we've already arranged you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom? But you understand the charge?
Yes, sir.
Well, as indicted without any enhancement paragraphs, this is a state jail felony. A state jail felony. No, it's not. You got the wrong case here. It is a state jail. You're considering the other. All right, it is a state jail felony. State jail felony carries a punishment range without any enhancements of not less than 180 days, nor more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. You understand the range of punishment?
Yes, sir.
In the plea bargain?
Thank you, Judge. In CR 20-0239, the agreement is for 90 days county jail under 1244A, plus court cost, any fees and restitution in what is $180 to DPS. the state will ask the court to take into consideration CR 19-0495.
Is that your understanding of the plea bargain, Mr. Oliver? Is that your understanding, Ms. Moore?
It is. I believe, I'm not sure if he said he had credit for
sorry?
time. I'm not sure if he mentioned that he has credit for time served. but
We
he-
show him to have 102 days.
That's what I show.
Yes, that's our agreement, Your Honor.
All right, and Mr. Oliver, then a few minutes ago, you told me you could read and write the English language. I'm going to go over two documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back and sign that with Ms. Moore?
Yes, sir. Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second page?
Yes, sir.
Any questions about it?
No, sir.
Do you have any questions about any of the documents you signed with Ms. Moore?
No, sir.
Well, if you read and went over these with Ms. Moore, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that state jail felony offense as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason? I hear the evidence.
Thank you, Judge. The state offers in the evidence states 1, 2, and 3. States 1 is the offense report. States 2 is the Morton discovery, and states 3 is the lab report.
No objection.
Admitted.
Nothing further, rest in close.
Your Honor, we'd rest and close. Ask the court to follow the plea bargain.
All right, Mr. Oliver, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the indictment. The court will, actually, I didn't go over the range of punishment on a misdemeanor. Back up a little bit. Mr. Oliver, I didn't go over the range. I failed to see this was punished under 1244A, which is basically punishing you as a Class A misdemeanor. The punishment range for that is up to 1 year in the county jail and a fine not to exceed $4,000. Knowing that now, does that change your previous plea?
No, sir.
All right, sir. Well, then the court follows the plea bargain, sentences you under 1244A of the penal code to 90 days in the Henderson County Jail. Court grants the state's abandonment of enhancement paragraphs 1 and 2. In punishing you, the court has considered the previous cause number CR 19-0495-392 and orders you to pay your attorney's fees, court costs, and both of those lab fees. And then before you go, Mr. Oliver, had you had an opportunity to review the judgment in your case?
Yeah.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. Good luck to you. You need to see Mr. Halbert before you leave. Jason Tucker.
Yes.
Jason Tucker. All right, these are cause numbers CR 20-0161-173, 162, 163, 164, 165. All style, the state of Texas versus Jason Tucker. All set for trial docket status. However, a plea on 161 and 162 have been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Tucker,
Mr. Tucker is present and ready.
all right, sir, is your name Jason Christopher Tucker?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for both of these burglary of habitations in 161 and 162 cases?
Yes, sir.
I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Tucker, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Tucker, have you ever been treated for or any mental health or emotional issues.
No.
You understand what's going on in here today.
Yes, sir.
And Ms. Moore, do you believe your client is competent?
I do, Your Honor.
The court's going to find that he is competent. Mr. Tucker, I know that you've already been arraigned on these two cases. However, would you like the prosecutor to read the indictments against you out loud here in the courtroom?
No, sir.
If you understand the charges.
Yes.
Well, as indicted, this CR 20-0162 case is a state jail felony. A state jail felony carries a punishment range of not less than 180 days nor more than 2 years in a state jail felony facility and a fine not to exceed $10,000. You understand that range of punishment?
Yes.
All right, you're gonna have to speak a little louder. I've got this
I got
glass in front of me. All right, and now in this CR 20-0161 case, that case, burglary of a habitation, is a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment
you. Yes, sir.
in the plea bargains in each of these cases?
Your Honor, in CR 2161, it's 5 years deferred adjudication probation with credit for 180 days served. There's a $1,500 fine, attorney's fees, court costs, all the regular terms and conditions of probation apply. In CR 2162, it's 24 months confinement in a state jail felony facility, probated for 5 years with 180 days credit towards a potential sentence. There's court costs in this case, and these two sentences are to run concurrent with each other.
Is that your understanding of the plea bargains, Mr. Tucker?
Yes.
Is that your understanding, Ms. Moore?
It is, Your Honor. I think on your paperwork, I think what Mr. Cox's intent is from after our negotiations and talking is that Mr. Tucker spent 10 months in county jail. The state is basically requiring he forfeit 180 days of that as condition of probation
That's
and
right.
giving him credit for time served. And I think I tried to fix that on those original papers, so it may not be reflected on.
It is on the burglary case. It's 180 days, but there's no time credit on the burglary of a habitation case.
The court can mark that in, that's fine with the state.
Okay, so I'm gonna put 180 days.
So we're basically wiping out 6 months worth of back time.
Understood.
And Mr. Tucker understands that. And
Okay.
yes, Your Honor, that's our understanding of the plea bargain agreement.
Well, Mr. Tucker, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple documents with you in each of these cases. The first is the agreed plea recommendations. Same form, but different information on them for each of these cases. Did you read and go over the front of each of those with Ms. Moore?
Yes, ma'am.
Did you
Yes,
sign it?
sir.
It's okay. Did you read and go over the back with her?
Yes, sir.
And did you sign the backs of those?
Yes, sir.
The next document I'm going to refer you to and show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, I'm just showing you one, but there's one for each case. Did you read and go over each of these with Ms. Moore?
Yes, sir.
And did you sign the second page of that document on each of these cases?
Yes, sir.
Do you have any questions about it? Do you have any questions about any of the documents you read and signed related to these pleas today with Ms. Moore?
No.
Well, if you read and went over these, I know she explained to you that you have many constitutional rights, including the right to trial by jury in each of these cases. Do you want a jury trial?
No, sir.
Do you want to enter into these plea bargains?
Yes, sir.
Then I'll ask you, sir, in cause number CR 20-0161-173 to that second degree felony offense as alleged in the indictment, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Now, in cause number CR 20-0162-173 to that state jail felony offense as alleged in the indictment, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I'll hear the evidence in each case.
Judge, for both causes, I have states 1, which is an offense report. States 2 and states 3 are both discovery compliance.
I have no objection.
Admitted in each case. Rest of close.
Yes, sir.
All right, and anything on behalf of Mr. Tucker?
Well, Your Honor, just to say that Mr. Tucker, during this pandemic, the court allowed a bond reduction for Mr. Tucker on the condition that he go to the Iron House program. which he successfully completed. I sent the letter of his completion, which was really just a glowing report, how he became a leader in the program, to the prosecutor. I think that's probably what helped them decide to offer this probation. He also has worked 2 jobs. The prosecutor received a very glowing job performance letter from him yesterday. And so he's really somebody who's turned his life around. So we're really, really proud of him today and hoping that the court will follow the plea bargain.
It's awesome, Mr. Tucker. I mean, I will tell you that this is kind of they're pre-pandemic. I may not have accepted this. I don't know. But I think it's awesome that you completed the Iron House and that you got a job. I'd much rather have you a productive member of society than my taxpayer money going to house and feed you. But I will pay it to house and feed you. And I do. All right. And so then I haven't pronounced sentence on anything yet. All right. So in this CR 20-0161-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding, follows the plea bargain, places you on 5 years community supervision. The court, in punishing you, is considering the CR 20-0163, 0164, and 0165-173 cases. You do have time credit for 180 days as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and to abide by all the regular and special terms and conditions of community supervision. In this case, will run concurrent with CR 20-0162-173. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty. The court will follow the plea bargain, sentences you to 2 years in a state jail felony facility. However, the court will probate that, place you on community supervision for 5 years, gives you 180 days credit and orders you to pay your court costs and to abide by all the regular terms and conditions and special terms and conditions of community supervision. And of course, this case will run concurrent with the 0161 case. And Mr. Tucker, a couple more things to go over with you. First of all, have you ever been on probation before?
Not felony.
Not a felony. Well, you've been on misdemeanor probation. Is that correct?
Yes.
Did you successfully complete it?
Yes, sir.
Well, then you know what it takes. There's a whole lot of things you can't do and a few things you have to do on probation. You understand that? I might have said that backwards. A whole lot of things you have to do and a few things you can't do. First of all, do you know what can happen to you, especially in this burglary of a habitation,
Yes.
if you violate any term or condition?
Yes.
What can happen?
2 to 20.
That's right. That's the downside of a deferred. The good side is you don't get the conviction if you successfully complete it. Downside is you're open to the full range of punishment. So here's what can happen. If you violate any one condition or term of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if the court found it were true that you violated even one term or condition, the court could revoke your probation, find you guilty, and sentence you up to 20 years in prison. You understand that?
Yes, sir.
Same thing in this burglary of a building case. Motion, warrant with no bond, because this is a regular probation. You'd be held in jail till you got a hearing. And at that hearing, if the court found it were true, the court could sentence you up to 2 years in state jail. You understand that?
Yes.
So would you agree with me? It's extremely important you abide by these. You've
100%.
been doing it for the past few months, so I hope you continue to.
Yes.
And sir, one last thing, now that you have been found guilty in that burglary of a building case, you're now under Texas law ineligible to possess a firearm or ammunition. If you have any, can't talk, if you have any questions, consult an attorney.
Okay.
Good luck to you, Mr. Tucker. You need to see probation before you leave.
Okay.
All right, this is for Mr.
Oh, you need to see the thumbprint on the state jail case. Thank you for reminding me.
That's on Mr. Tucker. And I forgot to give you Mr. Oliver's.
That's the most important document.
Yes. Heaven help me, but really don't want to volunteer.
So Melanie, do you count each one of those cases? So that's another 5. 1, 2, 3, 4, 5. Yes, sir. Next, we have Jimmy Wilson.
Yeah.
Come on up, Mr. Wilson. Yeah, Mr. Wilson. Make this one difficult on me. Okay, let me get settled here. There's just one? Or is there a couple?
It's just one.
Just one, all right, makes it easy on me.
And Your Honor, it's one that the indictment does not allege the enhancements. The enhancements were alleged in a Brooks notice, bringing it to 3rd degree.
Okay, I'm just trying to figure out what we're doing. So he's going to plead on we're off the record. He's going to plead on the 153 case, which is the evading. And we're going to consider all these other ones.
Yes, Your Honor, and one is going to be an outright dismissal.
And the victims are all on board with this?
They've been notified, yes, Your Honor.
Okay. All right, so 153. So I don't jumble up the records. Evading arrest. It's a state jail originally. Y'all sent a Brooks notice with 2 prior state jails, which would have made it a 3rd, but you're abandoning those.
Correct.
So
And he'll plead true to those 2 paragraphs on the Brooks notice.
hold on a
They're
second.
not abandoning it. He's pleading true to the,
Okay, let me get that notice out.
actually alleged 3. And he's pleading true to the first 2.
Here's a copy of it, Your Honor.
That'll work, because I just need to take his plea on it.
Yes.
Like, make sure I get that back to you.
Okay.
So he's pleading true on the 2 of them.
The 2
First
first
top 2.
paragraphs. Yes,
Okay.
Your Honor.
I got you. All right. Sorry about that, Mr. Wilson. I think I got you figured out now. All right, this is cause number CR 20-0153-173, the state of Texas versus Jimmy Wilson, set for trial docket status. However, a plea has been presented to the court to resolve all his cases on the docket. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Wilson.
Mr. Wilson's present and ready, Your Honor.
All right, sir, is your name Jimmy Wilson Jr.?
Yeah.
And are you the same person that was originally indicted by a Henderson County grand jury for this state jail felony offense of evading arrest or detention?
Yes.
I can get you to raise your right hand, sir, best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Or you can lower your hand. Mr. Wilson, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes.
And Mr. Wilson, have you ever been treated for any mental health or emotional issues?
No.
You understand what's going on in here today?
Yes.
And Mr. Moore, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is competent. Mr. Wilson, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes.
Well, as originally indicted, this case is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment? However, after indictment, the state filed what we call a notice to enhance your punishment with the addition or by alleging that you had committed 2 prior state jail felonies. If that is true, then the range of punishment, if found guilty, is not less than 2 years in a state, not less than 2, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment? in the plea bargain?
Yes, Your Honor. In exchange for a plea of guilty on the evading arrest detention with previous conviction, the agreed plea recommendation is, in addition to pleading true to the 2 paragraphs on the Brooks notice, 4 years in the Texas Department of Criminal Justice Institutional Division, to give him time credit of 480 days as of today, to take in consideration the following indicted cases: CR 19-0248-392, CR 19-069-392, CR 20-0154-173, and CR 20-0320-173, and to take in consideration 3 unindicted causes. There's a robbery offense date of 7/24/2019, a robbery offense date of 5/24/2019, and a stalking date of offense 10/7/2019, and to dismiss CR 19-0247-392. Attorney's fees of $1,200 and court costs.
So the last dismissal is not at 12:45.
That is correct, Your Honor.
Okay. And the alleged victims in these cases have been notified and are on board with the plea bargains.
Yes, Your Honor.
Okay. Is that your understanding of the plea bargain, Mr. Wilson?
Yes.
Is that your understanding, Ms. Moore?
It is my understanding, and what I think the intent here is that Mr. Wilson is getting wrapped up. We found out about the unindicted cases last week. I think they've been pending for quite some time, and it's our intention that this district attorney's office is wrapping him up on this 4-year plea, and they don't have any more cases pending.
And that is correct, Your Honor.
That you know
However,
about?
That we know about, but he does have some pending misdemeanors that we did not take care of
And
today.
he's aware of that. Everything they have in the DA's office is taken care of, and we just want to make sure that was on the record.
All right, well, Mr. Wilson, I mean, he says everything is there, but I mean, if there was some offense that you were alleged to commit that they don't know about, it wouldn't be included in this. You understand that?
Yes.
So if it ain't on this paper, then you're not covered on it. You understand that?
Yes.
Okay. All right. And so that's your understanding of the plea bargain. That's your understanding, Ms. Moore.
It is, Your Honor.
All right. Well, Mr. Wilson, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and back and sign the front and back with Ms. Moore?
Yes.
Do you have any questions about it? The next document I'm going to refer you to and show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over that and sign the second page?
Yes.
Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Ms. Moore? Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this or any of these cases?
No.
You want to waive your right to a jury trial and enter into this plea bargain?
Yes.
Then I'll ask you, sir, how do you plead to that felony offense of evading arrest or detention as alleged in the indictment? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
Also, sir, is it true that in the 173rd District Court of this county in January of 2009, you were convicted of the state jail felony offense of credit card abuse?
Yes.
Is that true or not true?
It's true.
And
Yes.
are you pleading true because it is true and for no other reason?
Yes.
And is it also true or not true that in Tarrant County in 2012, you were convicted of the state jail felony offense of evading arrest? Is that true or not true?
Yes, it's true.
And are you pleading true to it because it is true and for no other reason?
It's true. Yes.
I'll hear the evidence.
Your Honor, state offers States Exhibit 1, the inventory offense report, States Exhibit 2, the inventory report.
We've reviewed that, have no objection.
Admitted.
State rests and closes.
And Your Honor,
Here's your Brooks notice back.
Okay, thank you.
we would rest and close and ask the court to follow the plea bargain.
All right, Mr. Wilson, then based upon your guilty plea and the evidence, as well as the pleas of true in the evidence, the court has enough evidence to find you guilty and does find you guilty. The court finds the 2 enhancement paragraphs true. The court will follow the plea bargain, considers the unindicted and indicted cases annotated on the plea recommendation sheet and sentencing you, sentences you to 4 years in the Texas Department of Criminal Justice with credit for 480 days, and orders you to pay your attorney's fees and court costs. And a couple more things to go over. Mr. Wilson, did you get an opportunity to review the judgment in your case?
Yes.
Was your name, the charge, and the time credit correct?
Yes.
And finally, sir, now that you've been convicted of this felony offense, you're now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. And sir, you're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, Mr. Wilson. You need to see Mr. Halbert over here before you leave.
Your Honor, that's all I have this morning. Maybe it's used until
Yes,
this
ma'am.
afternoon.
Thank you.
Thank you. Oh, Your Honor, can you get a copy of this judgment?
Absolutely. Mr. Harrington.
Just on page 6, William Killingsworth, you have a plea to present to the court.
That's all right. I'm here all day. All right, this is cause number CR 20-0133-392, the state of Texas versus William Henry Killingsworth. Set for trial docket status today. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Killingsworth,
Or present ready, Your Honor.
right, sir, is your name William Henry Killingsworth?
Yes.
And are you the same person that was originally indicted by Henderson County Grand Jury for this felony possession of a controlled substance?
Yes.
I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You can lower your hand. Mr. Killingsworth, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? Mr. Killingsworth, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on in here?
Yes.
And let's see, Mr. Harrington, do you believe your client is competent?
Yes, sir, I do.
And the court's going to find that he is competent. Mr. Killingsworth, I know that you have already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No.
But do you understand the charge?
Yes.
Well, as indicted with those 2 enhancement paragraphs, that is a 3rd-degree felony. A 3rd-degree felony carries a punishment range of not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes.
In the plea bargain?
Thank you, Judge. The agreement is 2 years TDC plus court cost, attorney's fees, $180 in restitution to ETS, and the state will take into consideration an unfiled felony indictment.
Is that your understanding, Mr. Killingsworth?
Yes.
Is that your understanding of the plea bargain, Mr. Harrington?
Yes, sir, it is.
Mr. Killingsworth, a few minutes ago, you told me you could read and write the English language. I want to show you 2 documents. The first is the agreed plea recommendation. Did you read, go over, and sign both the front and the back with Mr. Harrington?
Yes.
Do you have any questions about it? The next document I want to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages and sign the second page with Mr. Harrington?
Yes.
Do you have any questions about it? Do you have any questions about any of the documents you read and went over with him?
No.
Well, if you read and went over these with him, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to enter into this plea bargain?
Yes.
Then I'll ask you, sir, how do you plead to that felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty?
Yes.
And
Judge, It's a true third degree.
Is
The
it?
Elements, those two enhancements are false. They need to be abandoned. It's a true third degree. With two improper enhancements. So we'll abandon the improper.
Yeah, because it wouldn't have done anything if this is,
No.
okay. So I'm going to back up there. Well, the punishment range I gave you was
It was
correct. And so you're abandoning these enhancements.
Yes.
So I'll ask you again, Mr. Killingsworth, I see it now, it's 1 to 4.
Yeah.
So how do you plead to the third degree felony offense of possession of a controlled substance more than 1 gram but less than 4 grams as alleged in the 4 grams as alleged in the indictment? Guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason?
Yes.
You caught me just in time. I was fixing to take
That
this
was-
pleas of truth.
Something sounded weird about
All right, and I'll hear the evidence.
Thank you, Judge. State offers into evidence states 1, 2, and 3. 1 is the offense report. 2 is Martin compliance, and 3 is the lab report.
Objection.
Admitted. Anything else?
Nothing further, resting close.
Resting close.
All right, Mr. Killingsworth, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that felony offense of possession of a controlled substance. Court will follow the plea bargain, sentences you to 2 years in the Texas Department of Criminal Justice with credit for 70 days. In sentencing you, the court has considered that failure to appear from December 17th of 2020 and orders you to pay your attorney's fees, court costs, and lab fees. A couple more things, Mr. Killingsworth, have you had an opportunity to review the judgment in your case?
Yes,
Is your name, the charge, and the time credit correct?
yes.
And finally, sir, now that you've been finally convicted of this felony, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. And you now remanded back to the custody of the sheriff for transport to the appropriate authorities. Good luck to you, Mr. Killingsworth. You need to see Mr. Halbert before you leave.
Thank you.
Thanks, Judge.
Yes, sir. Get a few more.
You just on page 4 and 5.
Justin Edis. What are we doing here? This plea?
No, Your Honor.
Okay. All right. These are cause numbers CR 20-0063 through 0069-173 and all styled the state of Texas versus Justin Edis and all set for trial docket status.
Your Honor, if the court recalls, a few weeks ago, Mr. Harrington filed a motion to set bond. Court heard testimony. In that testimony, the court heard about an incident that took place in Denton County. Mr. Edis has since been indicted. We found out late last week he's been indicted in Denton County on 2 counts of online solicitation. What we're asking the court to do today is to reset trial docket announcement for about another month. Mr. Harrington and I would like to confer with the powers that be in Denton County and see if we can work out a package deal that would wrap up his cases here as well as his cases in Denton County. Additionally, Judge, we received from the victim who's present in the courtroom today some additional information from her that we made available to Mr. Harrington a couple of weeks ago, and it's quite, there's a lot of information in there. So I don't know if he's had a chance to review that or not, but I think another month would be good for all parties involved.
I agree with that, Judge. Particularly Denton County may be something that makes this
I understand. I
work
mean,
out.
for efficiency, you want to make sure it's all, if he doesn't enter into some kind of plea bargain, you want to make sure it's all wrapped up.
Yes,
So,
sir.
all right, Mr. Edis, you're the one in jail. You all right with that?
Huh?
Said you're the one in jail. You okay with setting this off?
I haven't got much choice, do I?
No, I could set you for trial the very next,
Yeah, I'll set it off. Where Mr. Harrington
Good idea. Follow the advice of your lawyer.
He's a pretty good lawyer.
All right. All right, I'm gonna set this for a status July 15th at 1:30
Thanks, Judge.
because the new case is involved. So we'll see you in July the 15th at 1:30.
Thank you, Judge. Judge, maybe it's speak to this afternoon.
Yes, sir. Yes, sir. So if you count all the cases.
First count is 17. All the cases.
I count cases.
It may be more than 17.
And when I was DA, I counted counts in cases. So, because it's true. I mean, each count is a case. All right, so we've got him on Zoom. All right, good afternoon, everybody. We're getting ready to call the 1:30 docket. Just a few housekeeping notes. First of all, if you're appearing via Zoom, if you don't mute your microphone, we can hear you. So unless it's your turn to talk or testify or whatever, please keep your microphone muted. Also, if you don't click that little button that says stop video, we can see what you're doing. And although it may be entertaining, it can be distracting. So if you wouldn't do it in the courtroom, please don't do it on Zoom. I think we only have one, but that's all right. And then for those in the audience, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. It's your decision, not mine. Your decision. I'm not going to tell you. As far as the inmates, I require them to wear a mask because they don't have an option. They have to be here. And so with that, we'll go ahead and take, oh, one other thing. Attorneys, if you need to talk with Kevin, he's appearing via Zoom. If you could just text him, and that way you can communicate with him. He's here, but you can't talk with him unless the rest of us here. So with that, Ms. Moore.
On page 6, Lisa Greer.
All right, Ms. Greer. You can do this too. All righty, this is cause number CR 19-0741-173, the state of Texas versus Lisa Greer, set for trial docket status. I think we're going to pass this one by agreement. Is that correct?
Yes, this morning I passed one, I believe it was June the 9th.
Is that right, William? June 9th?
That'll work.
Okay. So June the 9th at what time?
1:30.
All right, so June 9th at 1:30. And let's see, before you leave though, Ms. Greer, based upon the nature of your charge, the morning you take a drug test, you'll go take the drug test when you get done.
That's for the clerk,
Come back in
sorry.
the courtroom and we'll go over the results together.
Okay.
Don't leave until we talk.
Okay.
Right.
That's all I have, Your Honor. I'm just waiting.
Mr. Skelton.
Dina Thomas, she's on the last page, I think.
All right.
And I did sit down with her and go to sleep.
I can't hear you.
Oh,
You don't
sorry.
have, have you done the plea papers yet?
We got it, they're being prepared, and we're gonna go over, I just want to announce what we. we'll
Oh,
be
okay.
doing a plea.
All right, well, I'll write you down as doing a plea then.
Okay, thank you.
Yes, sir. Other open announcements, 1:30 docket. Going once, going twice. All right, if you hear your name called, just let me know you're here. You don't have to come up. Christopher Morgan.
Runner, as far as I know, he's still at the hospital. The hospital faxed over a notice this morning earlier.
Kevin, did we get that?
Yeah, I got it, and I gave Danny a copy.
I've seen it.
Don't you love the miracles of modern technology? Okay, so then what are we going to reset that to?
All right. After May 22nd,
June 9th?
June 9th,
Is that good, Kevin?
That's fine.
What time? 1:30?
Yes, sir.
You do that, Rick?
perfect, Judge.
June 9th, 1:30.
Thank you.
All right, let's see, Billy Wayne Cantrell. Gotcha. William Hesseltine. Got you. Joe Parolini. Joe Parolini. Oh, Paroline, sorry. Liney, Paroline. I didn't even think about it.
No answer.
It's Miss Fallhaber?
She's in the back of one of the clients.
She is? Okay.
She's in the back of this one, so.
All right, CR 19-0864-173, the state of Texas versus Joe Paroline. Set today for trial docket status. Is there a Joe Paroline in the courtroom? I see no one, I hear no answer. Is there a Joe Paroline appearing via Zoom? I see no one, I hear no answer. His name was called 3 times in the lobby. He did not respond. Time is 1:33. The docket was set for 1:30. The court will entertain a motion. Granted, a capious will issue, he'll be held with no bond. If he shows up later, I'll reconsider. William Stanciel, gotcha. Louis Corwin, got you. Efren Garcia, got you. Where are you from, Mr. Garcia? Where are you from? Okay, I went to college with an Efren Garcia. Make sure you're not him. Christy Lawler. That's the one we reset from this morning. Okay. Raymond Mathis.
Present via Zoom.
Gotcha. He's here via Zoom, Ronnie. Rand Leeds is in the back. Andre Johnson Senior or Junior, sorry. All right, this is cause number CR 19-0794-173. The state of Texas versus Andre Johnson Jr. Set for trial docket status. Is there an Andre Johnson in the courtroom? I hear no one. I see no answer. Is there an Andre Johnson appearing via Zoom? See no one, hear no answer. His name was called 3 times in the lobby. He did not respond. Time is now 1:35. The docket was set for 1:30. The court will entertain a motion. Granted, capious will issue. He'll be held with no bond. Again, I'm here for the rest of the afternoon if we can find him. Morgan Taylor. She here, Ms. Mayhaw?
She is here.
Okay.
We're like, son of-
Yes, ma'am. William Kennedy. Got you. Carrie McCoy.
She's here, Judge.
Okay. Matthew McEwen. Crystal Thompson.
She's here.
Kevin Espinosa Vera. Okay. Mark Allen Lofton. Gotcha. Ms. Thomas is here. Tedrick Rockmore.
Judge, he's here. He's out in the
Okay.
lobby, and I'm gonna be in line in just a couple of minutes.
All righty. All right, Ken, continuing on with open announcements. Ms. Fallhaber, you got anything ready?
I was just standing here.
Well, you're in the line.
I think we might be ready on William Hessel time.
Okay. Cause number CR 19-0863-173, the state of Texas versus William Hesseltine. Come on up, sir. This is set for trial docket status.
Your Honor, the state is ready for trial. We filed a motion for special request, special setting, I'm sorry. We would request that be set on the June 28th trial date.
Kevin?
And may I respond, Your Honor?
Yeah.
Defense is not ready. There's still CPS records that I'm waiting to receive from the state.
That is correct, Judge.
All right, then I'm
We
gonna
requested those.
reset this trial docket status thing because we don't have all the discovery. Kevin, when you want to reset it?
Hold on one sec. We can reset it for June 9th at 9 o'clock.
So I'm going to reset trial docket status June 9th at 9 a.m. So as soon as you receive your reset notice, Mr. Hesseltine, you're free to go. We'll see you back on June 9th. Yes, sir.
I'm also ready to announce on William Stanton.
William Stansel. This is cause number CR 19-0702-173, the state of Texas versus, that's for me. Tell them I'm on the bench. I'll call them back. State of Texas versus William Stansel set for trial docket status.
Your Honor, the state made a 10-time offer to Ms. Fallhaber. It's our understanding that offer is going to be rejected. State's ready for trial.
What's the offer?
For TDC,
Any enhanced alleged priors?
no, Your Honor.
What was the underlying felony?
Which one?
What's unlawful possession of firearm by
Actually,
felon?
Judge, the underlying felony is unlawful possession of firearm by a felon. He has a number of felony convictions. That's why I asked.
Any of them involving possession of controlled substance?
No, Your Honor.
Okay. Ms. Fallhaber?
We're ready.
Okay. All right. What number is he, Kevin?
41.
You're going to move up pretty quick, Mr. Stansel, so I'm not going to give you a reset notice now. This Chinese pandemic that we're in has caused us to be delayed by a year, but you're going to move up pretty quick. So stay in touch with your bondsman and your attorney, and you'll receive a notice when you're set for trial. Righty, sir. Mr. Head.
Mathis appearing by Zoom.
He's appearing by Zoom because
He works in Fort Worth and I had
Okay, I
sent him a
remember, yeah.
notice by Zoom.
Mr. Mathis, you got me?
Yes, sir, I do.
Okay, I'm going to call your case, and this is cause number CR 19-0918-173, the state of Texas versus Raymond Mathis Jr., and set for trial docket status.
Your Honor, the state's offer was 5 deferred. It's my understanding that that's being rejected.
That's correct, Your Honor.
However, I understand it's going to go on the rolling trial docket. However, Mr. Head and I will continue to work towards a resolution in this while it's on the rolling trial docket.
Okay. What number is he, Kevin?
47.
47. All righty. All right, Mr. Mathis, you hear all that?
Yes, sir, I did.
All right, so you're not going to receive a reset notice. However, your next setting will be setting you for trial. So just stay in touch with your bondsman if you have one and your attorney, and we'll see you on that trial announcement whenever you get it.
Yes, sir.
All right, thank you. You can log off.
Thank you.
Your Honor, Louis Corwin.
Louis Corwin. This is cause number CR 19-0737-173, the state of Texas versus Louis Corwin, set for trial docket status.
Yes, sir. The state has made an offer. I've learned from Mr. Head this afternoon, he's received additional information which might affect when we're going to be able to proceed.
Your Honor, it's a little bit of an unusual fact pattern. It's a breach of a lease, but there's an issue about whether or not the conduct was civil or whether there might be some sort of criminal issue. And so if we could have one more setting, we will do our best to resolve it, Your Honor. It's we're providing information and trying to work through those issues.
June 9th, Kevin.
Yeah, let me check something real quick though. June 9th at 1:30. Mr. Head will already be here.
June 9th, 1:30. So Mr. Corwin, as soon as you receive that reset notice, you're free to go. We'll see you back on June 9th at 1:30.
Yes, sir. Thank you.
You're welcome.
Have excuse, John.
Yes, sir. Appreciate you.
Your Honor, we're ready for a plea on Ms. Lawler.
Okay.
She's not quite ready yet.
That's all right. We can just, you have something else you can announce first? Or-
Your Honor, I've got one more, but we need to do a jury waiver on it.
Okay, well, let's go ahead and get Ms. Waller up. I can start. The state has their copy of it. It's kind of hoping they'd start walking in. All right, this is cause number CR 20-0356-392, the state of Texas versus Christy Lawler. Set for a plea this afternoon. Is the state ready?
We are, Your Honor.
And on behalf of Miss Lawler,
We're ready, Your Honor.
all right, ma'am, is your name Christy Lawler?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for, is it a third degree? I don't have the paper.
It is, Your Honor.
Third degree felony offense of possession of a controlled substance.
Yes, sir.
I'm going to need you to pull that mask down because I can't hear you.
Yes, sir.
All right, I need you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, you can lower your hand. Ms. Lawler, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes, I am.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
Ms. Lawler, have you ever been treated for any mental health or emotional issues?
No.
All right. So you think you had to think about that?
No, I didn't think about that.
Okay. Do you understand what's going on in here
Yes,
today?
I do.
All right, and Mr. Head, you believe your client is competent?
I do, Your Honor.
The court's going to find she is competent. Ms. Lawler, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, you don't have to.
But do you understand the charge?
Yes.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand the range of punishment? And the plea bargain?
Your Honor, we're asking the court to defer a finding of guilt and place her on probation for a period of 5 years with a $500 fine, court costs, lab restitution fees, and all the regular terms and conditions of probation.
Is that your understanding of the plea bargain, Ms. Lawler?
Yes.
Is that your understanding, Mr. Head?
It is, Your Honor.
Ms. Lawler, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents. The first is the agreed plea recommendation. Did you read and go over both the front and the back and sign them with Mr. Head?
Yes, I did.
Do you have any questions about it?
No.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea.
Yes.
Did you read and go over that with Mr. Head?
We went over this. We did.
And did you sign it?
Yes, I did.
Do you have any questions about it?
No. I know.
Do you have any questions about any of the documents you read and went over with?
No.
Well, if you read and went over these with Mr. Head, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, I think the probation is going to help me. a
Right? Do you
lot.
want to enter into this plea?
Yes.
And I'll ask you, ma'am, how do you plead to that third-degree felony
I plead
offense?
guilty to a third-degree felony.
Hold on a second. Let me ask the question and then you answer it.
I'm sorry.
She's got to write down everything, and if we're talking over one another, she's going to get upset at me. And then, all right, all right. How do you plead to that third-degree felony offense of possession of a controlled substance? Are you guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are guilty? And for
Yes,
no,
I'm pleading
hold on a
guilty.
second. You're doing it again. Are you pleading guilty because you are guilty and for no other reason?
Sorry.
I'll hear the other.
Judge, I have states 1, a offense report, states 2 is Michael Morton, and states 3 is a lab report.
No objection, Your Honor.
Admitted.
State rests.
Your Honor, we would rest and close. One, I think the attorney's fees may have been left blank and I am court appointed on it. So
Okay. Is that part of the plea bargain?
Your Honor, we understood. I explained to Ms. Lawler
Okay.
that the court appointed attorney's fees. would be
Understood.
a-
I just put them in there.
Yes,
All right,
sir.
so nothing else?
No, sir, Your Honor, rest and close.
All right, Ms. Waller, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defers making any finding, places you on 5 years community supervision. You do have 3 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and lab fee. And Ms. Waller, have you ever been on probation before?
Yes, I've been.
Did you successfully complete it?
No, I was not successful
All right, what happened in that one?
at all.
No, I mean, what was your punishment on it?
I was in 6 months in county jail or state jail.
Okay. Well, do you know what can happen if you violate?
Yes, I do.
What can happen?
I go to prison for 2 to 10 years.
That's right. If you violate even one term or
Yes,
condition, hold on. You violate even one term or condition, a motion would be filed, a warrant would be issued for your arrest. You'd be brought back before the court, and if the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, sentence you up to 10 years in prison. You understand that?
Yes, I do.
So would you agree with me that it's extremely important you abide by these terms and conditions?
Yes.
I hope you do, man. Good luck to you. No, you don't need to see anybody but probation.
Your Honor, if I could be excused for just a minute,
Yes, sir.
this is Mr. Garcia.
Mr. Mills.
I think we'll do Matthew McKeown. He's in jail.
All right, this is cause number CR 19-0806-173, the state of Texas versus Matthew McKeown. This is set for trial docket status. Where are we at?
Your Honor, we actually already have this case specially set for August.
Okay.
I think the court said it today, just see if we could maybe resolve the case. We've not been able to get our heads together yet.
Is there an offer or not?
Right now, no, because the offer that had been made by Mr. Hall had been rejected, and we have not made a new one.
Okay. All right, well then, when is it set, Kevin, especially?
Jury trial announcement is August 9th at 9 o'clock and jury trial August 23rd at 8:30.
And the August 9th, you said, is it 1:30?
9 o'clock.
9, okay. All right, well then, Mr.
And
McKeown,
I'm sorry, Judge, we're set number 1 that day. Is that
set
right?
number 1, specially set. So, Mr. McKeown, we're going to make announcements on this on August 9th at 9 a.m. And then we'll pick a jury beginning at 8:30 on August 23rd. And so we'll hear motions and limiting anything else that day on August 9th as well.
Sounds good, Judge.
Okay, all right. As soon as you receive your reset notice, Mr. McKeown, you have a seat. Ms. Greer, you passed your test. You're free to go. Yes, sir.
Up here on William Kennedy.
Kennedy? William Kennedy. This is cause number CR 18-0513-173, the state of Texas versus William Kennedy, and set for trial docket status.
Your Honor, I sent Mr. Mayo over a new offer this week of 6 years TDC. I've also sent out subpoenas for counseling records, CPS records, school records, and medical records.
On a 3-year-old case, and we're just now sending those out?
I understand, Your
Did you
Honor.
just inherit it? Okay.
There, and I'm not sure you know this, you may know it, there are a ton of CPS records that Mr. Dickerson, I believe, had ordered.
Who?
Pink Dickerson.
Oh, okay, yeah.
And they were here at one time. I've been over here to look at them. but I don't have them. They were redacting them during that time.
Well, I think we're getting around that lately by issuing a protective order. 3914 precludes you from giving them to him anyway.
Right,
So
right.
Your Honor, I've been through the file. I haven't seen those records.
Oh.
I will look for them.
There is.
I reordered them. I didn't realize they'd been ordered before.
let's do this. Let's reset it. Kevin, how about June 9th at 1:30?
That'll work.
All right, I'm gonna set it for a status. June 9th at 1:30. I understand y'all are inheriting a lot of these cases. I'm just gonna back this one up to status since we don't even have all the discovery.
I appreciate that, Your Honor.
Okay, so I'm gonna back it up to status.
Judge, just so that I can let the court know, and I've just confirmed this, I'm gonna be, or I hope to be, out of town from June 15th to July the 5th, coaching a bunch of 18-year-old boys
Okay,
in baseball in Florida and in Georgia. So if we
with which,
can-
which organization?
it's Marucci. I
Okay,
coach the
yeah, I'm
18
familiar
years.
with it. My son plays for the Dallas Patriots.
Oh, does he?
We
Okay.
travel around. I know what you do.
Yeah, I'm in this deep and been in it for
I understand.
25 years.
Well, then we'll just do June 9th. So June 9th are good, right?
June 9th is good.
Okay.
I can be here June 9th.
All right, June 9th at 1:30.
Okay, thank you,
All right.
Judge.
All right, as soon as you receive your reset notice, Mr. Kennedy, you're free to go. Ms. Thompson. This is cause number CR 19-0153-173, the state of Texas versus Crystal Thompson, set for trial docket status.
Judge, this case is several years old. They previously made their several offers of deferred years ago, which were all rejected. I'm trying to talk to Mr. Cox into maybe dropping it down to a misdemeanor, and he said he needs time to look at it. This is an old case that he's just not getting, so.
I'm here all day.
I know.
I do, my notes, Judge, reflect back in February, I did make an offer of misdemeanor probation with restitution.
If we could talk, I don't know if that's going to be accepted.
Shaking her head no.
I mean, it's on the table.
I know. We could reset this to May the 5th or June the
Wednesday.
9th or whatever those.
Well, how
This
about
is-
May 5th?
That's fine with the state.
That's fine with us.
Cinco de Mayo.
When the offer's not going to get any much, I mean, we're kind of to the, it's either take it or go to trial.
Kevin, when's that May 5th time?
1:30.
Can we do it then?
Yeah, we'll make it work.
That's a Wednesday. Okay, May 5th, 1:30.
Hang on, hang on. I'm not sure. It seemed like that does kind of ring a bell.
If we did, I'll ask to recall that.
I don't think we do.
Maybe a previous court date or something. It's a question of, anyway, so, all right, you got that? Make it, that's next week. Okay. See you then. Then we have a plea on Kerry McCoy, Judge.
Kerry McCoy.
Don't leave. Don't leave.
All righty. This is cause number CR 18-0207-392, state of Texas versus Carrie Ann McCoy. And this is set for a plea this afternoon. It's a state ready.
It's ready, Your Honor.
And on behalf of Ms. McCoy,
We're ready, Judge.
ma'am, is your name Carrie McCoy?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury in paragraph C? That's
Yes.
C of the indictment to abandoning or endangering a child.
Yes, sir.
I need you to speak a little louder because I got this stupid glass between us.
Yes, sir.
And so if I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Now you can lower your hand. Ms. McCoy, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen, you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
Ms. McCoy, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
Mr. Mills, do you believe your client is competent?
She is.
The court finds she is competent. Ms. McCoy, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, that charge in paragraph C is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
In the plea bargain?
Your Honor, the state recommends 5 years deferred on the abandoned and dangerous state jail felony to include 310 days credit as of today, standard terms and conditions, $500 fine, $750 attorney's fees, $299 in court costs, Crime Stoppers fee, drug testing, GED within 24 months, 200 hours of community service, substance abuse evaluation, and an anger management class.
Is that your understanding of the plea bargain, Ms. McCoy?
Yes, sir.
Is that your understanding, Mr. Mills?
Yes, Judge.
Well, Ms. McCoy, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back and sign them with Mr. Mills?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages and sign that second page with Mr. Mills?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over with him?
No, sir.
Well, if you read and went over these with him, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
And I'll ask you, ma'am, how do you plead to paragraph C of that indictment, that state jail felony offense? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, the state offers Exhibit 1, a copy of the offense report, and Exhibit 2, the initial inventory report.
No objection.
Admitted.
State resting close.
Good rest.
All right, then, Ms. McCoy, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding, follow the plea bargain, places you on 5 years community supervision. You do have credit of 310 days as to any sentence you may eventually have to serve. And orders you to pay your fine, attorney's fees, court costs, and to abide by all the regular and special terms and conditions of community supervision. Ms. McCoy, have you ever been on probation?
No, sir.
All right, well, there's a lot of things you have to do and a few things you can't do on probation. Do you understand that?
Yes, sir.
Do you know what can happen to you if you violate any term or condition?
Yes, sir.
What can happen?
Prison,
For how long?
2 years.
2 years.
Then do you know how state jail time is served?
Day
How?
for day.
Typically day for day. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest. You'd be brought back before the court, and if the court found it true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 2 years in state jail. Do you understand that?
Yes, sir.
So would you agree with me? It's extremely important you abide by it.
Yes.
I hope you do. Good luck to you. You need to see probation before you leave.
And that's all I have.
Thank you. Thank you. I'm stealing all your paper clips today. Don't say any sorry. Mr. Stevens.
Heather Whitmore, Your Honor, last page.
Very last one on the docket.
And who is this again? I'm sorry.
Tedrick Rockmore, Your Honor.
Okay, and okay, that's, all right. All right, this is cause number CR 19-0140-173, the state of Texas versus Tedrick Rockmore. Trial docket status.
Judge, we've reached an agreement for a plea.
Okay,
We're gonna sign a jury waiver and ask you to reset it for a plea date.
for a plea date or
Yes,
for an
sir.
open plea?
No, a regular agreed
Okay,
plea
and do
date.
you have the jury waiver?
Right here, Judge.
Yes, sir. Right here.
All right. All right, Mr. Rockmore, I'm going to have to place you under oath, but I'm not going to ask you any questions about this alleged offense, nor am I going to let anyone else. I just need to ask you questions about this, okay? All right, if you can raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Rockmore, I've been presented with this waiver of jury, which appears to have your signature on there. Is that your signature?
Yes, sir.
Well, do you understand, sir, and I'm sure Mr. Stevens explained to you, but that the United States Constitution and the Texas Constitution guarantee you the right to trial by jury? Do you understand that?
Yes, sir.
And you could not be found guilty of this offense unless 12 jurors found you guilty beyond a reasonable doubt. You understand that?
Yes, sir.
And nobody can take that right away from you. Mr. Stevens can't, prosecutor can't, I can't, nobody can. It's your right. Do you understand that?
Yes, sir.
And if you enter into this waiver of jury and I approve it, if something happens and this plea bargain blows up, you're not going to have that right because you just waived it. You still have a right to have a trial before the court, but not before a jury of your peers. Do you understand that?
Yes, sir.
You still want to do this?
Yes, sir.
All right. And is that your signature on that document?
Yes, sir.
And Mr. Stevens, do you believe that he's entered into this waiver freely, knowingly, and involuntarily?
Yes, sir, I do.
All right, and then the court has signed it, finds that the state has consented and approves this the 29th day of April, 2021. And when are we setting this for a plea?
We haven't agreed on a date. We just need to get a date, Judge, maybe a month out or something like that.
Kevin, something a month away?
June 9th at 1:30.
June 9th, 1:30.
Judge? You sure? Yeah, yeah. That'd be good, Judge. Yes, sir.
June 9th, 1:30. All right, Mr. Rockmore, as soon as you receive your reset notice, you're free to go, sir.
Yes, sir. Thank you.
Yes, sir.
Thank you, Judge. And that's all I have. May I be excused?
Sure.
And may I be excused?
Good to see you. Yeah. I want to go see the county attorney's office in the morning. And I don't go to the main courthouse. Run me off when I go over there. Last time I went over, they took my temperature and I wasn't happy about it. Ms. Fallhaber.
Billy Cantrell.
Billy Wayne Cantrell. This is plea. What are we doing on this one?
It was set for a probable cause hearing today, and I just wanted to make an announcement on it.
Okay, this is cause number CV 21-0161-173 ex parte Billy Wayne Cantrell. And set today for a writ habeas corpus for probable cause. And so you had an announcement, Ms. Fallhaber?
I do, Your Honor. In anticipation of today's hearing, I have met with the state. We've actually worked out a plea agreement for all of his cases in exchange for waiving the probable cause hearing today. They're going to be indicted next week, is my understanding, and then we'll request a plea date.
Whatever the court has available after.
Are
next
you filing an
Thursday.
information or are you still taking it to the grand
We're
jury?
going to take it to grand jury.
And are these officers subpoenaed for that case?
One of them was, yes.
Okay.
I didn't hear the question.
Was there an officer subpoena?
Oh,
I'm saying I see them back there. I don't know if you can release them when we're done.
Oh,
here.
no, they're here for something else,
Okay.
Judge.
All right, well then you can release the witnesses and then I will, if you can file a non-suit because it's a civil case, since it's a writ. If not, they just start to stack up.
yes, sir.
You can do that for me. And then Mr. Cantrell, you get indicted, then I guess we'll see you back here.
We go ahead and get a date, Judge, after next Thursday for a plea.
Only problem I see with that is Judge Calhoun won't be back till the 14th to set bonds from that grand jury.
Well, and we don't know, I guess, as a practical matter, if the case might wind up in Judge Calhoun's court.
That's true. Let's just wait and see what happens.
All right,
But
we'll
for my client's ease of mind, the offer will still be
Yes,
available.
yes, regardless of which court it ends up in.
Yeah, Mr. Cantrell, I get 80% of the felony cases, but I don't get 20% of them. So, and it's all random. You may end up in Judge Calhoun's court.
So if I was to bond out and that parole reinstates my parole, the offer still. be
I
there?
can't hear you with that mask on.
If I bond out and parole is my blue warrant hold and I get back out on parole, and when the court date comes up, it'll still be the same offer, and then I just get locked up that day?
You got to ask him. I don't know.
I don't think you're getting out between now and the time that we do the plea.
My understanding, no matter what happens with these charges, the blue warrant's not being lifted.
I don't have any control over any
All right,
blue
I'm
ones.
just asking that question.
Understandable.
Appreciate it.
Okay.
Okay.
All right. All
So-
right. If we see it, we'll see. If not, then if you'll just file that motion in non-suit.
Thank you, sir.
Absolutely.
Thank you, ma'am.
And the last one that I have, Your Honor, is Joe Paroline. I haven't seen him.
Mr. Caroline was not here. I don't know if he is now. No, I didn't know if he had showed up. Yeah, I called when there was nobody, so I called all the way through the docket. There was no Joe Caroline here.
Oh, I was in the back room
Right.
talking to somebody. I'm sorry.
That's all right. I'd take it. If there's nothing ready, I take attendance. That way we don't have to do it later, but I've
Okay.
already granted a bond forfeiture and set a no bond, but if I'm here all day, if you find him.
If he turns up. All right,
All
thank
right.
you. That's all I have. Can I be
Yes,
excused?
ma'am.
Thank you.
Well, that's what it is, right? Taking attendance? Ms. Mayhaw, you ready? Okay, and what are we doing on this one? All right. These are cause numbers CR 19-0352 and 0353-392, both styled the state of Texas versus Morgan Taylor. And a plea set for pleas today, and a plea has been presented on the 352 case. Is the state ready?
State's ready, Your Honor.
And on behalf of Ms. Taylor,
We're ready, Your Honor.
all right, ma'am, is your name Morgan Ray Taylor?
Yes.
And are you the same person that was originally indicted by a Henderson County grand jury in this case for the first-degree felony offense of aggravated promotion of prostitution?
Yes.
I get you to raise your right hand. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You can lower your hand. Ms. Taylor, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen, you enter into this plea bargain with the state, can have certain negative immigration consequences. Do you understand that?
Yes.
And Ms. Taylor, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on in here today?
Yes.
And Ms. Mayhaw, do you believe your client is competent?
Yes, I do.
And the court finds that she is competent. Ms. Taylor, I know that we already arraigned you some years ago on this. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom? I said some years because your case is a couple years old. We arraigned you a long time ago.
No, we'll waive the reading.
All right, but do you understand the charge?
Yes.
Well, as indicted, that charge is a first-degree felony. A first-degree felony carries a punishment range of not less than 5 years or more than 99 years of life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand the range of punishment
Yes, sir.
in the plea bargain?
Your Honor, it's 10 years confinement in TDC, probated for 5 years with 308 days credit, plus court costs and all the regular terms and conditions of probation apply.
And is the complaining witness or the victim
And
on
it-
board with the plea bargain?
Put down.
Yeah, I think he went over that.
I can't, is that a yes?
I'm sorry, Judge.
The victim, is the victim on board with the
I
plea?
believe so. And I have to check with Ms. Pace. She had to, yes.
The victim's aware of the conditions of the plea, and it was an agreement that the defendant plead with these conditions.
Okay. All right. And is that your understanding of the plea bargain, Ms. Taylor?
You understand, is that your understanding of the plea bargain? Yes, I mean,
mean-
it's 10 years probation, correct? It's 5 years probation.
What he just said, is that what your understanding of it is?
10 years probation for 5. Yes.
Yes?
Yes.
Okay. Is that your understanding, Ms. Mayhaw?
Yes.
Ms. Taylor, a few minutes ago, you told me you could read and write the English language. I'm going to show you two documents. The first is the agreed plea recommendation. Did you read and go over both the front and back and sign them with Ms. Mayhaw?
Yes.
Second document I'm showing you is the court's admonishments and waivers. Forgot what I was going to say, court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document and
Yes.
sign the second one? You
Yes.
got to answer out loud.
Yes.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over with Ms. Mayhaw?
No, sir.
Well, if you read and went over these documents with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to enter into this plea bargain?
Yes, sir.
Then I'll ask you, ma'am, how do you plead to that first degree felony offense? It's actually, you're doing a lesser included.
Yes, Judge.
How do you plead to the lesser included offense of that which is charged in the indictment, that lesser included being promotion of prostitution of persons younger than 18? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I hear the evidence.
Judge, I have states 1 in offense report and states 2 is Michael Morton compliance.
No objection. Your Honor.
Admitted.
State rests.
Any evidence?
No.
Right, rest and close. All right, then, Ms. Taylor, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense of promotion of prostitution. The court, in punishing you, is considering cause number CR 19-0353-392. The court sentences you to 10 years in the Texas Department of Criminal Justice. However, the court will probate that, place you on community supervision for 5 years. You do have 308 days credit as to any sentence you may eventually have to serve, and orders you to pay your court costs and abide by all the regular and special terms and conditions of community supervision. And Ms. Taylor, now that you have been finally convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, consult with an attorney. And last, Ms. Taylor, have you ever been on probation before? You know what can happen to you if you violate this probation?
Yes, sir.
What can happen?
I can go to prison
For how long?
99 years.
No, actually, it's up to 10 years.
Okay, well, yes, sir. I
If
understand.
you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be placed in jail with no bond, brought back before the court, and at a hearing, if the court found it true that you violated even one term or condition, the court could revoke your probation and sentence you up to 10 years in prison. You understand that?
Yes, sir.
All right, well, good luck to you.
Thank you.
You need to see probation before you leave.
Your Honor, would like to announce on the record that that's the last felony case that I have and that I intend to take.
Well, good for you.
And I think I went going out on a good note.
Well, thank you. Congratulations, I guess.
And I won't be seeing you much.
We'll see you at the bar lunch.
Maybe
It's good to see you.
around, see you at Walmart, maybe.
Well, you won't see me at Walmart. I don't go to Walmart. There are zombies, like real life zombies in Walmart. Mr. Head.
Efren Garcia.
I asked him where he went to college, because I went to college with an Efren Garcia. It's just a name you don't hear very often. Mr. Garcia. Actually, kind of looks familiar. Stretch. Trying to swear. Who are you looking for? No, this is Efren Garcia. That's okay. All right, this is cause number CR 19-0908-173, the state of Texas versus Efren Garcia. And this is set for trial docket status. However, a waiver of jury has been presented to the court. And so, Mr. Garcia, I'm going to swear you in, ask you just some questions about this document. And I'm not going to ask you any questions or allow anybody else to ask you any questions about the offense, okay? If you can raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. You got to answer a little louder. She's got to write down what you say. All right, you can lower your hand. Mr. Garcia, I've been presented with this waiver of jury. Have you seen that document?
Yes.
And is that your signature on there?
Yes.
And I'm sure Mr. Head explained these to you. As a matter of fact, I know he did, but I'm going to explain them to you on the record. First of all, both the United States Constitution and the Texas Constitution guarantees you a right to trial by jury. Do you understand that? And nobody can take that right away from you. Not your attorney, not the state, not me. That is your right. Do you understand that? And Mr. Garcia, you could not be found guilty of this offense at a jury trial unless 12 jurors believe beyond a reasonable doubt that you were guilty. Do you understand that?
Yes.
Is that a yes?
And Your Honor, if we could have a translator here, I've gone over it with him, but I know some of the legal terminology when the court goes through it, it might be a little confusing to him.
Mr. Garcia, do you understand what I'm telling you about your right to a jury trial?
Yeah, but no.
I think he's just concerned about when you start talking about constitutional rights and some of that language is a little confusing to him. And I've explained, asked him if he understood what a jury was and if he wanted to waive that. But I do think what we're asking to do is to pass the actual plea to let me go over details with him with the translator.
Well, here's what I'll do is, first of all, well, let me ask you this, Mr. Head. Did you explain in detail his rights? I'm sure you did.
I did, Your Honor.
And do you believe that he's entered into this waiver knowingly, intelligently, and voluntarily?
I do, Your Honor.
All right, and well, then the court finds that he has. Court also finds that he's consented, or the state has consented, and the court is approving it the 29th day of April, 2021. And when are we setting this for a plea?
Your Honor, if we could maybe have 30 days, we've agreed on some sort of probation. We're talking about different terms and conditions, and so that's really the issue.
We're close. Maybe that June 9th date, if it's okay with
Kevin, we still got room on June 9th?
June 9th, 1:30.
June 9th, 1:30.
Voice of God.
Don't know. No, it's just a voice of technology.
Thank you, Your Honor. That's all I have now.
Yes, sir. We'll see you on June 9th, Mr. Garcia.
Thank you, sir.
Yes, sir. Mr. Scott.
And this is with an interpreter.
The one you were looking for.
You find it, Judge?
Sure. All right. Let me see. We're off the record. I'm seeing what we're doing.
1244B, Your Honor, state jail
1244B,
felony data,
considering-
1244B, time served and considering a misdemeanor.
I got you. He's not been arraigned yet. This is mostly on information. All right. Ready? This is cause number CR 21-0411-392, the state of Texas versus Kevin Espinoza Vera. And we have an interpreter here, so ma'am, if I could swear you in first, you solemnly swear that you will translate from English to Spanish and Spanish to English to the best of your ability.
I do. Laura de la Torre, license 2257.
Thank you, ma'am. All right. Sir, is your name Kevin Espinoza Vera?
Yes,
All right, and are you the same person that this information has been filed on this state jail felony?
yes,
You could raise your right hand, please, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your
Yes.
hand. Sir, can you read and write the English language?
no,
Did your attorney go over every one of these documents that you signed with you?
yes,
And did you understand what these documents meant and what they contain?
yes,
All right, and Mr. Espinoza Vera, are you a U.S. citizen?
no,
I hope you understand, though, that if you enter into this plea bargain with the state and the court accepts it, you can be subjected to certain negative immigration consequences.
yes,
And I'm sure Mr. Scott told you that he is not an immigration attorney, at least not unless he became one since. And that is really a special area of the law. And so I don't think anybody in this room can tell you what may happen to you if you go through with this. You may end up being deported. Do you understand that?
yes,
But are you aware that some negative things can happen?
yes,
Right, and you still want to go forward with this?
yes,
All right, and sir, have you ever been treated for any mental health or emotional issues?
no, no,
And do you understand what's going on in here?
yes,
And Mr. Scott, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is competent. Mr. Espinoza Vera, you have not been indicted in this case. Is that correct?
yes,
As a matter of fact, you have been charged by what we call an information, which is nothing more than the prosecutor alleging that you have committed this felony offense. You understand that?
yes,
Well, you don't have to do any of this today because in Texas, you have a constitutional right to have your case presented before a grand jury. And a grand jury is a body of 12 citizens that meet in secret. You don't have a right to be there, neither does your attorney. And at that meeting, they'll hear details of your case. If 9 or more believe there's probable cause to charge you, they'll return an indictment. If less than 9 believe there's probable cause, then you'd just be let out of jail. Do you understand that on this charge? You understand that?
yes.
You want to wait and see if a grand jury will indict you? Or do you want to go through with the plea bargain?
I want to go with the plea bargain.
Okay. All right. Mr. Vera, that document charging you that the prosecutor signed charges you with a state jail felony. And a state jail felony carries a punishment range of 180 days to 2 years in state jail and a fine up to $10,000. However, it's my understanding that you have this deal worked out with the state where in exchange for your guilty plea, they would recommend that the court convict you and punish you as a Class A misdemeanor. Right. The punishment range for a Class A misdemeanor is up to a year in county jail and a fine up to $4,000. Do you understand both those ranges of punishment? In the plea bargain?
Your Honor, it's 128 days confinement in the Henderson County Jail. Credit for 128 days served, a $500 fine, court costs, attorney's fees, or I'm sorry, $500 in attorney's fees, there is no fine. Court costs and lab restitution. Judge, the state's also against the court to 1245 an unindicted and unfiled unlawful carrying of a weapon. I believe that's.
I got it.
And Your Honor, we've also signed a form that we're gonna let the state seize that firearm, so he's not getting that back. And I think I accidentally gave it to you and I need to get that back. I think it
The
goes. in the
firearm or the form?
What's that?
The firearm or the form?
The firearm form. I'll take both. Yeah, I think that goes in the misdemeanor file.
This one?
Yes, sir.
I signed it.
Well, I'll make another spot in case Judge Perryman wants to sign it.
Mr. Espinoza Vera, did you hear the plea bargain that the prosecutor recited? Did he hear the plea bargain? And is that his understanding of the plea bargain? Is that your understanding, Mr. Scott?
It is, Your Honor.
Well, Mr. Espinoza Vera, a few minutes ago, you told me your attorney went over these documents and you understood them. I'm going to go over. We're missing the court's admonishments and warnings prior to entering a guilty and no contest plea. Do y'all have those? That's all right. If you hadn't signed them, I'm going to have to go over them with him. All right. Sir, I'm going to go over a couple documents with you. First is the agreed plea recommendation. Did Mr. Scott go over this document with you? And did you sign both the front and the back?
Yes,
Do you have any questions about it?
no,
The next document I want to go over with you is the defendant's waiver of rights to a grand jury. Now, I explained that to you earlier, but this goes into more detail. Did you go over that with Mr. Scott?
yes,
And did you sign it? Do you have any
yes,
questions about it?
no, sir.
And finally, normally there's a document here, but I'll go over it with you. First of all, not only do you not have to do this because you haven't been indicted, if you were indicted, even though you're not a US citizen, you are in the United States and you would have a right to trial by jury and many other constitutional rights. And at that jury trial, you could not be found guilty unless 12 jurors found you guilty beyond a reasonable doubt. Do you understand that? And at that jury trial, you would have a constitutional right to assist your attorney in cross-examining the witnesses against you. And you would even have a right to call your own witnesses or testify on your own behalf. But if you didn't testify and you didn't call any witnesses, nobody could hold that against you, and the jury would be instructed that they couldn't hold that against you. You understand that?
Yes.
And if you were to be found guilty beyond a reasonable doubt, and your attorney made, or if the court were made to make certain decisions during the trial, you could appeal the jury's verdict and the court's decision. Do you understand that? So when we have a form that's filled out, it goes a lot safer, smoother. All right, and do you want a jury trial? Or do you want the plea bargain?
I want to do what my attorney recommends.
Do you want a jury trial or do you want to do this deal? Which one?
I want to take the deal.
All right, well, then I'll ask you, sir. How do you plead to that state jail felony offense as alleged in the information? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I'll hear the evidence.
Judge, that states 1 in offense report, states 2, my more compliance, and stage 3 is a lab report.
No objection, Your Honor.
Admitted. Anything else from the state?
No, Judge.
Rest, Your Honor.
All right, then, sir, based upon your guilty plea and the evidence, court has enough evidence to find you guilty and does find you guilty by following the plea bargain of that Class A misdemeanor under 1244B of our penal code. In sentencing you, the court considers the unfiled misdemeanor, sentences you to 128 days in the Henderson County Jail with credit for 128 days, and orders you to pay your attorney's fees, court costs, and lab fee. And before you go, sir, did you get an opportunity to review the judgment in your case?
Yes.
Was your name, the charge, and the time credit correct?
Yes.
All right, sir. Then you're now remanded. Well, no, I guess you're remanded back to the custody of the sheriff for out processing unless you're being held on another charge.
He is, Your Honor. He's got a hold out of Dallas.
He needs to see Mr. Halbert to his right.
Thank you, Judge.
Thank
you, ma'am.
I've got one more, Your Honor, but I haven't signed it up fully yet, Your Honor.
Okay. You good? Okay. Just want to know you want to keep driving on. Mr. Mills.
Crystal Thompson.
Oh, there she is.
We've got a jury waiver worked out.
Oh, okay. Ready? Let's go back on the record and cause number CR 19-0153-173, the state of Texas versus Crystal Thompson. And it's my understanding that Ms. Thompson has entered into a waiver of jury trial. Is that
Yes,
correct?
sir.
And do you have it?
John, I believe it was submitted already.
Did I not give it back to whoever gave it to me? No, I didn't. Sorry.
Okay.
It's sitting in my file.
All right, Ms. Thompson, I'm going to swear you in, but I'm not going to let anybody ask you any questions about this alleged offense. I'm just going to ask you some questions about this document, okay? So I need you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Okay, you can lower your hand. Ms. Thompson, I'm holding in my hand a waiver of jury that your attorney handed me. Have you seen that document?
Yes, sir.
And is that your signature on it?
Yes, sir.
Well, I'm sure Mr. Mills explained this to you, but I'm going to explain it to you as well. Do you understand that the United States Constitution and the Texas Constitution guarantee you the right to trial by jury? You understand that? And nobody can take that away from you, not your attorney, not the state, not me. You understand that? And unless a jury of 12 people found you guilty beyond a reasonable doubt, you couldn't be found guilty of this charge. You understand that? However, by waiving this, you would be giving up that right. Now, if you waive this jury and your plea deal blows up somehow, you still have a right to trial, but it would be a trial before the court where it'd only be me, the judge, who would still, the state would still have to prove to me that you were guilty beyond a reasonable doubt. You understand that? But you wouldn't get the jury. You understand that? All right. And is this something you want to do? I'm sorry?
Yes, sir.
And did you sign it?
Yes, sir.
All right. And Mr. Mills, do you believe your client has entered into this waiver knowingly, intelligently, and voluntarily?
She did, Judge.
When the court finds that she has, further finds that the state has consented and I'm approving it, this the 29th day of April, 2021.
And Judge, we were here a minute ago, the court reset this for May the 5th. The deal we have worked out with the state is for a PTI, but she needs to come up with $300 up front to start that process. So she doesn't think she can have that by next Wednesday. Is it possible we could do it? Maybe
June is fine, Your Honor.
in June.
Kevin, we got time, June 9th?
June 9th, 1:30.
June 9th at 1:30.
How can I reset, Your Honor?
All right, Ms. Thompson, then as soon as you receive that reset notice, you are free to go. We'll see you back on June 9th at 1:30. Wait till you get that notice. Mr. Skelton? Dina Thomas. We don't have any, we don't have the paperwork.
Oh. No, no, Judge, we don't.
You need a few minutes?
Yeah, I think Mr. Skelton needs a few minutes with his client. Have you all gone over this thing?
Yes.
You don't have any paperwork?
No, I don't have it.
I've got the state's copy.
Let me ask y'all this, who gave it to the clerk?
I've got it.
Aha. Then she needs to be sworn.
And I need to sign it too. I haven't had a chance to.
Okay. All right, we're gonna have to, let me take Mr. Harrington, but he's got to sign it and she still has to be sworn.
All right, Your Honor.
Sorry, Mr. Skelton. I'm sorry.
On Mr. Harrington's case, we have a victim impact statement.
Okay, I'll just wait for, Mr. Skelton, go ahead and we'll go ahead and handle you next. We're gonna handle you next. We're just gonna get the paperwork straight first. I'm just gonna put you, yeah, right there. I had one the other day. I bought it at the daiquiri place in 7 Points. Andre Johnson. Well, let's handle that. Where's Mr. Johnson? Okay. Mr. Johnson, come on up. There it is, bottom of floor. All right, this is cause number CR 19-0794-173, the state of Texas versus Andre Johnson. This is set for trial docket status. The court called Mr. Johnson's name earlier and he was not present. The court had granted a motion to forfeit the bond and hold you with no bail. And he's here now. Mr. Harrington?
Your Honor, he contacted me numerous times before 1:30. He was having car troubles. He says he'll be a few minutes late. I could have reported that to the court earlier, but I was back.
I understand.
Yes, sir. But he-
Mr. Johnson, there's two things you don't want to be late for, your wedding and felony court. You understand?
Yes,
But I'm
sir.
glad you're here. Is there a motion to recall the?
Yes,
All right,
sir.
I'll recall it. So let's go ahead and hear trial docket status.
Judge, Mr. Harrington and I have been unable to reach an agreement at this point. We're asking that it go on the rolling trial docket. We will, in the meantime, continue to work towards a resolution, but we understand that today it's going to go on the trial docket.
Is there an offer?
Yes, sir.
Yes.
And the offer is
I believe it's 10 years deferred adjudication, I believe. Judge.
10 years deferred on a second-degree felony, 2 to 20.
I believe it's correct, Judge.
Let me double check. That sounds about right. Let me double check.
Are there any enhancements?
No, sir.
No, Your Honor.
Mr. Johnson, I presume you're innocent, just as you stand there. I don't know anything about your case, but I do know this, that a second-degree felony, if you're found guilty, you can't get it deferred. You understand that? And you could get up to 20 years in prison.
Yes, sir.
Is it?
Yes, I believe
It
that's
is 10 deferred.
Okay. All right, well then, the court will place this on the trial docket. What number is he, Kevin?
42.
42. You can move up quicker than you think you can because cases start pleading ahead of you. So
Okay.
I'm not going to give you a reset notice now, but stay in touch with your bondsman and your lawyer. And when you receive a notice for trial, you just need to make sure you're here, okay?
Yes, sir.
On time.
Gotcha.
All right, thank you, sir.
All right, appreciate it, Judge.
Uh-huh. Good now. We may be able to get through this in one shot without even taking a break and get on out of here. You have the daiquiri place at 7 Points. Near El Jacalitos. You know where Scotty's Exxon is? It's where 334, which is 85 and 274 across right there. These 7 Points, 7 roads coming. If they're bringing one through that. All right, Hank, we're ready now. Science things. All right, this is cause number CR 19-0378-173, the state of Texas versus Dina K. Thomas. And this is set for, is it set for a plea today?
I think it was set for trial docket announcement, Judge, but we have reached a plea agreement.
No, I'll find it. Set for trial docket status, but a plea has been presented to the court. Is the state ready?
We are, Your Honor.
On behalf of Ms. Thomas.
We're ready, Your Honor.
All right, ma'am, is your name Dina K. Thomas?
Yes, sir.
Are you the same person that was originally indicted by the state jail, by Henderson County grand jury for the state jail felony offense of possession of a controlled substance?
Yes, sir.
Would you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you guys. You can lower your hand. Ms. Thomas, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Ms. Thompson, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here today?
Yes, sir.
Mr. Skelton, do you believe your client is competent?
Yes, Your Honor.
The court finds she is competent. Ms. Thomas, I know that you've already been arraigned on this case, but would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
Do you understand the charge?
Yes, sir, I do.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days and up to 2 years in a state jail felony facility and a fine not to exceed $10,000. You understand that, right?
Yes, sir.
However, it's my understanding that you have this deal worked out with the state that in exchange for your guilty plea, they are willing to ask the court to convict and punish you under the 1244B of our penal code, which allows the court to convict you and punish you as a Class A misdemeanor, which carries a punishment range of up to a year in a county jail and a fine up to $4,000. Do you understand that punishment? In the plea bargain.
Your Honor, it's 3 days confinement in the Henderson County Jail with credit for 3 days served. She's responsible for attorney's fees, court costs, lab restitution, We are asking the court to take into consideration the possession of marijuana from June 6, 2019, and a unfiled and unindicted PCS less than a gram from June 6, 2019.
This is her first offense? If it is, she kind of broke in with a bang.
I believe it is, Judge. Let me double check the report.
That's okay. Is that your understanding of the plea bargain, Ms. Thomas?
Yes, sir.
Is that your understanding, Mr. Skelton?
Yes, Your Honor.
And Ms. Thomas, a few minutes ago, you told me you could read and write the English language. I've only got one document to go over with you because they didn't go over the other one. Y'all got to get those plea packets handled because it just takes more time in the court. All right, this is the agreed plea recommendation. Did you read and go over with Mr. Skelton, both the front and the back, and sign it?
Yes, sir, I did.
You have any questions about it?
No, sir, I didn't.
The next document I would normally go over with you, I'm going to go over with you in detail because you didn't get it. And that is that you have many constitutional rights, including the right to trial by jury. And at that jury trial, you could not be convicted unless 12 people believed beyond a reasonable doubt that you were guilty. Do you understand that?
Yes, sir.
Also at that jury trial, you'd have a constitutional right to assist your attorney in cross-examining the witnesses against you. You understand that?
Yes, sir.
You'd also have a right at that trial to testify on your own behalf or to call witnesses on your own behalf. But nobody could make you do that. You understand that? And if you didn't do it, I would even instruct the prosecutor they couldn't mention it. And I would instruct the jury that they couldn't consider the fact that you didn't testify or call witnesses. Do you understand that?
Yes, sir, I did.
And finally, if the court were called upon to make certain decisions during the case and you were found guilty, you would have a right to appeal the jury's finding and my findings. Do you understand that?
Yes, sir, I did.
Do you want a jury trial?
No, sir.
Do you want to waive your right to a jury trial and enter into this plea bargain?
Yes.
And I'll ask you, man, how do you plead to that state jail felony offense punished and convicted under 1244B of our penal code? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have states 1 an offense report, states 2 is Michael Morton compliance, and states 3 is a lab report.
No objection, Your Honor.
Submitted.
Judge, for the court's information, the court inquired earlier about many priors. Ms. Thomas does have some criminal history out of other states, Utah, Colorado, I believe Tennessee. However, I will point out to the court, the reason for this offer is that she gave a statement that was not recorded or written. So we had some issues with that, and that's why she's.
You
getting
have
this
a
time served.
possible 3822.
Yes, sir. So that's why she's getting this deal.
Anything else?
No, Judge, rest in close.
Mr. Skelton?
We rest close, Your Honor.
All right, then, Ms. Thomas, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty and sentences you under 1244B of our penal code to 2 days in the Henderson County Jail with credit for 2. The court in sentencing you has taken in consideration the 2 unindicted causes and orders you to pay your attorney's fees, court costs, and lab fee. And Ms. Thomas, I'm just going to tell you that pre-COVID, pre this Chinese virus, I wouldn't have accepted this. There's many pleas today I would have accepted, but these are different times. And so I just hope you know that. All right, so good luck to you, man. Before you go, though, have you had an opportunity to review the judgment?
Yes, sir.
All right, was your name, the charge, and the time credit correct?
Yes, sir.
All right, ma'am, you need to see Mr. Halbert to your right. Good luck to you.
Thank you.
Is this the last one? Here's what I'm going to do. Is it next to last? What's the last one? I need about a 15-minute break, but in about 5 minutes, can y'all meet me in chambers? Let's go ahead and take a break because we got a number of people here and I want to talk to the attorneys in chambers, but give me about 5 minutes. And we've been gone since 1:30. It's time for a break anyway.
Yes.
I'll check.
If we could look, yeah, I think he needs to take in the paper.
I do too.
We're gonna check with the clerk, but it went good. Yeah, it went good.
Okay.
Yeah, yeah. It did.
I looked it out.
No, no.
I'm calling for flight.
Well, I'm gonna know. I'll go.
Correct.
Oh, okay. I was wondering, I've never seen that. If I told him that I. Thanks. Oh, okay. Yes. No, sorry, the second page. That's it back. I'm sure he gets that. He is, he's the guy on the right.
All right. Be seated. Thank you. I was looking for you in your office. Let's see. I guess we need the clerks too. Oh, okay, I see her. I want to do this plea on information, Mr. Scott, first. I'll do yours first, Mr. Scott.
Judge, I'm ready.
All right, you're okay. I told you I was gonna take 15 minutes. I didn't take quite that much.
I like my client earlier. He said he's gonna do whatever his lawyer told him to do.
What's that?
My client earlier, he told you he's gonna do whatever his lawyer told him to do. That's,
Don't you wish all your clients would tell you
I
that?
wish. Yeah.
Mr. Lofton?
44B.
Come on up, sir. All righty, this is cause number CR 21-0410-392, the state of Texas versus Mark Allen Lofton. And this is set for a plea today on information. Is state ready?
Yes, Your Honor.
And on behalf of Mr. Lofton.
Ready, Your Honor.
Sir, is your name Mark Allen Lofton?
Yes, sir.
And are you the same person that was originally, or that has been charged by information with this state jail felony offense of possession of a controlled substance?
Yes, sir.
You can raise your right hand the best you can, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God.
Yes.
You can lower your hand. Mr. Lofton, if you don't mind, if you can pull that mask down a little bit. All right, thank you. All right, Mr. Lofton, can you read and write the English language?
Yes,
Are you a U.S. citizen?
yes,
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
yes,
And Mr. Lofton, have you ever been treated for any mental health or emotional issues?
no, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Scott, do you believe your client is competent?
Yes, sir, I do.
Well, Mr. Lofton, first, right off the bat, you have not been indicted by a grand jury. Do you understand that?
Yes, sir.
You know what a grand jury is?
Yes.
Can you tell me?
It's a court of 12 people that gather into the special case.
Okay, it's close. It's basically a body of 12 people that meet in secret, and they are presented with your case, and they decide whether there's probable cause to charge you. You don't have a right to be there or even know when it's going to happen, and your attorney doesn't have a right to be there. Do you understand that?
Yes, sir.
And at that grand jury, if 9 or more people believe that there's probable cause to indict you, they return an indictment. If less than 9 believe that, well, then a letter would go over the jail to saying, hey, release Mr. Lofton on that charge. You understand that?
Yes.
You just want to stop everything right now and see if a grand jury will indict you?
No.
Okay, I'm not trying to talk you in or out of it. I just got to let you know your rights. You want to keep going. Well, that information charges you, and information is like an indictment, but it's just a piece of paper signed by the assistant district attorney alleging that you've committed this offense. And they have charged you with a state jail felony offense, which carries a punishment range of not less than 180 days or no more than 2 years in a state jail felony facility and a fine up to $10,000. Do you understand the range of punishment?
Yes, sir.
However, it's my understanding in exchange for this guilty plea, the state is recommending to the court that you be convicted and punished as a Class A misdemeanor under 1244B of our penal code. A Class A misdemeanor carries a punishment range of up to a year in a county jail and up to a fine of $4,000. You understand that?
Yes.
All right. And the plea bargain?
Your Honor, it's 24 months deferred adjudication probation with a $500 fine, attorney's fees, court costs, lab restitution, and all the standard terms and conditions of probation apply.
Is that your understanding of the plea bargain, Mr. Lofton?
Yes, sir.
Is that your understanding, Mr. Scott?
Yes, sir.
Mr. Lofton, a few minutes ago, you told me you could read and write the English language. I'm going to go over 3 documents with you. The first is the agreed plea recommendation. Did you read, go over, and sign both the front and the back?
Yes.
Do you have any questions about it?
No.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over and sign both pages? I'm sorry, sign the second page of that document.
Yes.
Do you have any questions about it?
No, sir.
The next document that I'm referring to and showing you is the defendant's waiver of rights to a grand jury. Now, that just goes into more detail of what I explained to you earlier. Did you read and go over that?
Yes.
With Mr. Scott? And did you sign it?
Yes.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over with Mr. Scott?
No, sir.
And I forgot to ask you this earlier, but do you want the prosecutor to read this information out loud?
No, sir.
But you understand it?
Yes.
Well, if you read and went over all these documents with Mr. Scott, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to waive your right to a jury trial and enter into this plea bargain with the state?
Yes.
And I'll ask you, sir, how do you plead to that felony offense as alleged in the information, punished and convicted as a Class A misdemeanor? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason? Is there any other reason you're pleading guilty other than you are?
No.
I'll hear the evidence.
Judge, out of states 1, an offense report, states 2, Michael Morton compliance, and stage 3 is a lab report.
No objection, Your Honor.
Admitted.
State rests.
Defendant rest, Your Honor.
All right, then, Mr. Lofton, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you, I'm sorry, has enough evidence to find you guilty. However, the court will defer making any finding, places you on probation as a Class A misdemeanor for a period of 24 months. and orders you to pay your fine, attorney's fees, lab fee, and to abide by all the regular and special terms and conditions of community supervision. And Mr. Lofton, have you ever been on probation?
No, sir.
Do you know what can happen to you if you violate this probation?
Yes, sir.
What can happen?
Up to 2 years.
It's actually up to a year in county jail. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest. You'd be brought back before the court, and at a hearing, if the court found it true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to a year in county jail. You understand?
Yes, sir.
So would you agree with me? It's extremely important you abide by these.
Yes.
I hope you do. Good luck to you, Mr. Lawson. You need to say anything to him about when he gets out of jail? Okay.
I'll give you that. Thank you. Have excused?
Yes, sir. Appreciate you hanging out with us.
Yes, sir. Thank you.
There's gonna be 5, please. You hear me, Ron? Maybe 5, so it's gonna spread them out. That's why I wanted to talk to them in chamber, see what we were doing. Yeah, I'd just like to know how many cases we resolved. Not, we shouldn't count pleas, resolutions. Because those are cases that are done, gone. Me too. Actually, stop the wrong one. There we go. All righty. Are we ready?
Yes, sir.
All right, Mr. Eads, come on up.
I'm just gonna start on page 3, 4.
All right, these are cause numbers CR 20-0254, 0255, 0295, 0296, 97, and 98-173, all style the state of Texas versus Randall Eads. And before we get started, if we can arraign Mr. Eads on the 25, 295, 296, 97, and 98 case, he's not been arraigned yet.
He has not judged, but he has reviewed the indictments. And you're ready for me to go forward now on those arraignments?
Yes, sir.
Your Honor, he has reviewed the indictments on those 4 charges you just numbered. His name is spelled correctly. He understands the charges, will waive the formal reading of the indictments and your plea of not guilty for the purpose of arraignment.
All right, sir, the court notes your plea of not guilty for the purposes of arraignment. And so we will adjourn the arraignment. Now, I'll call cause numbers CR 20-0254, 0295, 0296, 0297, and 0298-173, all set for a plea. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Eads,
Your Honor, we're present, ready.
all right, sir, is your name Randall Eads? All right, I need you to take that mask down, please. And are you the same person that was originally indicted in this 254 case through the first-degree felony offense of sexual abuse of a child, in this 295 case of the third-degree felony offense of possession of child pornography, in the 296 case to the third-degree felony offense of child pornography, the same in the 297 case, and also in the 298 case, those also being third-degree possession of child pornography cases. Is that you?
Yes, sir.
I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial of all of these causes will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Now you can lower your hand. Mr. Eads, can you read and write the English language?
I can. Yes,
I'm just going to set these up here. I don't need to take it. All right. Are you a U.S. citizen?
Yes, I am.
If it turns out you're not a U.S. citizen and you enter into these plea bargains with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, I do.
And Mr. Eads, have you ever been treated for any mental health or emotional issues?
No, I haven't.
Right. And do you understand what's going on in here today?
Yes, I do.
Mr. Harrington, do you believe your client is competent?
Your Honor, I believe he is competent. That's my opinion. He's a competent state trial.
And the court's going to find that he is competent. Mr. Eads, I know that we just arraigned you on some of these cases and previously arraigned you on this 0254 case. However, would you like the prosecutor to read each of these indictments out loud or any of these indictments here in the courtroom?
No, sir.
But do you understand the charges?
I do.
Well, as indicted, this 254 charge, the charge of sexual abuse of a child continuous, is a first-degree felony. A first-degree felony carries a punishment range of not less than 5 years. Is this the different train? Is this the 25?
It's 5 to 99 or life. There's no parole eligibility.
I got you. So this first-degree felony offense carries a punishment range of not less than 5 or more than 99 years or life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Your Honor, I misspoke. It's 25 to
I
life.
thought it was. Let me go over that again. Mr. Eads, the punishment range on this 254 case is 25 to 99 or life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, I do.
On these other cases, which you intend to plead guilty on, the 295 through the 298 cases, those are all third-degree felonies. A third-degree felony carries a punishment range of not less than 2 years, nor more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand the punishment ranges in each of those cases?
Yes, sir.
And the plea bargain in all the cases? You just recite them all.
Yes, Your Honor.
Listen carefully, Mr. Eads.
In CR 20-0254-173 for abandoning the enhancement paragraph, Your Honor. He's pleading to 40 years TBC with payment of attorney's fees and court costs. In addition to abiding by an agreed lifetime protective order, run concurrent with CR 19-0366-173, CR 21-0295-173, CR 21-0296-173, CR 21-0297-173, and CR 21-0298-173. And cause numbers CR 21-0295-173, 0296, 0297, and 0298. The plea agreement is for 10 years TDC with payment of attorney's fees and court costs, and to consider CR 21-0299-173, CR 21-0300-173, through CR 21-0314-173.
And he has credit for credit on those cases.
Your Honor, on CR 20-0254-173, he has credit for 441 days. And in 0295, 6, 7, and 8, he has credit for 16 days.
And I mean, it's asking, yeah, I keep asking, but on the child pornography cases, are you abandoning the enhancement paragraph?
Correct, Your Honor.
Is there just one?
I'm
I didn't
sorry.
look at it. Is there just one enhancement paragraph on that?
Yes, Your Honor.
Okay. All right. Did you hear all that and understand it, Mr. Eads?
Yes, I did.
And is that your understanding of the plea bargains?
Yes, sir, it is.
And Mr. Harrington, is that your understanding of the plea bargains?
It is, Your Honor.
Well, Mr. Eads, a few minutes ago, you told me you could read and write the English language. Is that correct?
Yes, I did.
All right, I'm going to go over a couple documents with you, but I'm not going to go over one for each case, but there is this same document for each case. The first is the agreed plea recommendation. I'm showing you the one for 0254, but all the other cases have the same form, just different information on it. You understand?
Right, I understand.
Right. In each of these cases, did you go over the agreed plea recommendation?
Yes, I did.
This one has your plea bargain. And did you sign both the front and back of the one I'm showing you?
Yes.
And did you sign the other ones?
I did, sir.
Do you have any questions about it?
No, sir.
The next document I'm going to show you, and again, there's one for each of these cases because the form applies to each of these cases. I'm showing you one, but the only thing different on the others is the cause number. And that is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over this document on each of these cases with Mr. Harrington?
We did, sir.
And did you sign the second page of each of those documents?
I did.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over on any of these cases with Mr. Harrington?
No, Your Honor.
Well, if you read and went over these with Mr. Harrington, I know that he explained to you that in each of these cases, you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in any of these cases?
No, sir.
Do you want to waive your right to a jury trial in all of these cases?
Yes, sir.
Do you want to enter into these plea bargains in all these cases?
Yes, sir, I do.
Then I'll ask you, sir, in cause number CR 20-0254-173, to that first degree felony offense of sexual abuse of a child continuous as alleged in the indictment, are you guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are guilty and for no other reason?
I'm guilty.
And cause number CR 21-0295-173, to that third degree felony offense of possession of child pornography as alleged in the indictment. Are you guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are guilty and for no other reason?
I'm guilty.
Is that a yes or a no?
Yes. Yes.
And cause number CR 21-0296-173, to that third degree felony offense of possession of child pornography. Are you guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are guilty and for no other reason?
Because I am guilty.
Is that a yes?
Yes, yes.
And cause number CR 21-0297-173, to that third degree felony offense of possession of child pornography as alleged in the indictment. Are you guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, I'm guilty.
And finally, in cause number CR 21-0298-173, to that third degree felony offense of possession of child pornography as alleged in the indictment, are you guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
I hear the evidence in all of these cases.
Your Honor, in CR 20-0254-173, we offer states 1, a copy of the offense report. States 2 is our voluntary statement from the defendant, and states 3 is a supplemental to the offense report.
No objection, Your Honor.
Admitted.
Your Honor, and the other 3 cause numbers, CR 21, I'm sorry, the other 4 cause numbers, CR 21-0295-173 through CR 21-0298-173. We offer states 1, a digital forensic analysis report.
No objection, Your Honor.
Admitted.
State rest.
Are we rest closed?
All right, Mr. Eads, in CR 20-0254-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that first degree felony offense as alleged in the indictment. Court will follow the plea bargain, grants the state's motion to abandon the enhancement paragraph, sentences you to 40 years in the Texas Department of Criminal Justice with credit for 441 days. The court has considered cause number CR 20-0255-173 in sentencing you and orders you to pay your attorney's fees and court costs. And the court is also ordering you to abide by the lifetime protective order in CR 21-0201-173. In this case, will run concurrent with CR 19-0366-173 and CR 21-0295, 96, and 97, as well as 98-173. And cause number CR 21-0295-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third degree felony offense as alleged in the indictment. The court grants the state's motion to abandon the enhancement paragraph and sentences you to 10 years in the Texas Department of Criminal Justice with credit for 16 days. The court in sentencing you on this case has considered CR 21-099-173, CR 21-0300-173, 301, 302, 303, 304, 305, 306, 307, 308, 309, 310, 311, 312, 313, and 314-173. And orders you to pay your court cost. And this will run concurrent with CR 19-0366-173, and then CR 20-0254-173, and CR 21-0296, 97, and 98-173. And cause number CR 21-0296-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense of possession of child pornography. The court will follow the plea bargain, grants the state's motion to abandon the enhancement paragraph, sentences you to 10 years in the Texas Department of Criminal Justice with credit for 16 days, and orders you to pay your court costs. This case will run concurrent with CR 19-0366-173, CR 20-0254-173, and CR 21-0295-96. I'm sorry, this is 96, CR 21-0295, 97, and 98-173. And cause number CR 21-0297-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense of possession of child pornography. The court grants the state's motion to abandon the enhancement paragraph, follows the plea bargain, sentences you to 10 years in the Texas Department of Criminal Justice with credit for 16 days, and orders you to pay your court costs. This case will run concurrent with CR 19-0366-173, and cause number CR 20-0254-173, CR 21-0295, 96, and 98-173. And finally, in that 298 case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty, does find you guilty of that third-degree felony offense of possession of child pornography, grants the state's, there's not one in that one, follows the plea bargain, sentences you to 10 years in the Texas Department of Criminal Justice with credit for 16 days, orders you to pay your court costs. And of course, this case will run concurrent with CR 19-0366-173, CR 20-0254-173, and CR 21-0295, 96, and 97-173. Mr. Eads, in each of these cases, there was a judgment of conviction. I'm showing you one, but there's one for each one, and each one's different. Did you have an opportunity to review the judgments in each of these cases with Mr. Harrington?
We did.
In each of those cases, was your name, the charge, and the time credit correct?
Yes, it was.
All right, sir, I've got to still get the other ones. Now that you've been finally convicted of these felony offenses, you are now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms. If you have any questions about that, you need to either refer to the document in your plea packet and or consult with an attorney. And sir, you're not going to go anywhere. You're going to stand there, but when we're done, you're remanded to the custody of the Henderson County Sheriff for transport to the appropriate authorities to serve out your sentence. And do we have some allocutions or victim impact statements?
We do, Your Honor, and also in CR 20-0254-173, if the court wanted to admonish him regarding his lifetime sex offender registration.
Yes, sir. And do you understand, did you go over that document on the lifetime sex offender registration with Mr. Harrington?
We did.
All right, I'm going to show it to you just so we have it on the record. Thank you for reminding me of that. All right, I'm showing you this sex offender requirement. Did you go over that?
Yes.
And did you sign it?
Yes.
All right, and do you have any questions about it?
No, sir.
Well, now that I've just found you guilty, you understand that you have to register for life.
I understand.
So if you move, you've got to tell some people, you got some hoops to jump through. Do you understand that?
Okay.
Get a job, there's lots of requirements. All right. And,
That's all, Your Honor, other than our victim statement.
all right, Mr. Eads, if you will please turn around. And who do we have?
Rio Nichols, Your Honor.
Okay.
The only thing that exists is myself, and the person who this. So what am I gonna do about it? And here's my first thought, whether I leave it to the law enforcement or go after it myself, it's still, I think my daughter was molested. And that can never be. I should be happy that he's going to jail. Honestly, I don't. As long as it's sexually abuse your child, sexual part. I want to play this not your fault. You hear it, brother. I know. You should always feel safe. People tell me my fault. Never changed. I should have changed. In my child's eyes for people I should ever have to experience. Christmas is especially hard because most things 7-year-olds are ready to go to sleep. But secretly decided to stand on for you presents. My daughter was being molested. The first time it happened, and it's hard to see. I'm afraid for her. The pain of this will ease up. Not one day go by. She grew years. After purchasing a place, over cry for a while. She goes through, she still won't talk to me about it. I trust you, I hate you, I hope you suffer, I will sever a go and learn to control yourself. Is it that hard to not get sad? The 11-year-old is smarter than you. Yes, ugly, I don't know why my mom did.
Turn back around, Mr. Eads. Thank you, ma'am. All right, Mr. Eads, I'm going to have you have a seat in the jury box. I got to get your judgments together here. And then if we can just hold him for a second, because I've still got to sign all these papers. Thank y'all. Have you excused? I'm just going to clear everybody out before he signs the judgments.
Maybe excuse me.
Yes, I just got to sign all these things. I didn't want to do it in the middle, but here you go, Ronnie, I got them. I think I signed these. I just need to sign all these three papers. Yes, sir, thank you. Yes, appreciate it. I'm just signing these plea papers. I didn't want to do it in the middle of all that. I'm finished, yes, sir. I'm just catching up on paperwork. My phone has been blowing up since I've been up here.
I know, it's a lot. Yeah, it's a lot.
It's
I
gonna
think
be a
we got
minute.
it. We try to double check, but it's a lot.
Yeah, it is. It's a lot.
No, I'm still going through it all, signing it. Boy, they put, not only did they send him away for 40 years, last thing she said, you're ugly too. I hate you and you're ugly. I don't know why my mama ever dated you. William, you still with us? William should probably check that a long
Wait,
time.
just waiting to be dismissed.
Instead of 90 from one indictment for child pornography for every image you had. I would get to a point where somebody got a PCS and they were a repeat offender, and they didn't charge it within a school zone or a church. I would get on Google Earth, put the location of the arrest. That's why I wanted to talk to the state. I didn't know all of this. We went back there. I'm like, okay, I got all these pictures on where were we fixing? I knew it was complete, but I didn't know what. So that should be everything.